All right, ladies and gentlemen, the September 16th meeting of the Board of Zoning Appeals is now in session. Good evening and welcome to this meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Inta Malice, Chair of the Board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Peter Owen and members Judy Freshman, Paul Melnick, and Portia Clark. Also present is the professional staff, including Stephen Rizzi, coordinator for the BZA, Cliff Hogan, assistant zoning administrator, Mark Hamela, zoning technician, and Matt Busing, acting assistant to the zoning administrator. For the safety of our board members, county staff, applicants, and participating community members, we are a virtual meeting today, and all participants are joining remotely. We are legally authorized to hold this virtual meeting based on the governor's executive orders, legislation adopted by the Virginia General Assembly, and the Arlington County Board's Continuity of Operations Ordinance adopted in March of 2020. We thank you for being here and extend a warm welcome. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals. Then I will also share some ground rules on how we will conduct this virtual meeting. The staff reports for each case on tonight's agenda can be found on the BZA website. Staff has placed a link, to the agenda in the chat section of the session. If you have not seen the report for your case, you may wish to review it before your item is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. 2, we can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of the decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of the society in the neighborhood, will not be detrimental to the public welfare or injurious to property improvement or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and the land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development within the surrounding neighborhood, because the structure's overall footprint, size, and placement are similar to structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by preponderance of the evidence that the improvements shall meet the following criteria. The strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or at the time of the effective date of the ordinance, or that the granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to the adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not so general or reoccurring in nature as to make reasonably practical the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change in the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. The order of our meeting is as follows. First, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff that they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any of the speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient. 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all information they need and has discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Now I would like to briefly orient everyone to our new virtual environment and to cover a few specifics about how this evening's meeting will run. Tonight's meeting is available to stream from the county's website via a Microsoft Teams link. There is also a dial-in phone option for those who wish to use it. If board members, presenters, or speakers lose internet connectivity during today's meeting, please reconnect with us by phone. Please keep your phones and devices muted until you are called upon. Turn off any sound to any other devices around you to minimize interference. For guests joining us via Teams, please turn off your video feed. Only board members will leave their cameras on. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located on your meeting command bar. The moderator does not have the ability to unmute you. The meeting chat is active for presenters or board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about the agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Board members will be recognized to speak on an item and will seek recognition verbally as usual. If we find that is sometimes unworkable, we also have the option to use the raised hand function. In either case, once you have been recognized, you may unmute yourself. If we have any board members who have joined by phone without the video option, I will check verbally to see if you wish to be recognized. All voting today will be taken via roll call. To applicants and public speakers. Public speakers and applicants, you will be called upon by county staff at an assigned time. Pre-registration to speak at today's meeting was requested. We will accommodate any additional speakers only if time permits. Public comment will take place within the timeframe stated earlier, the same as we would provide at an in-person meeting. During public comment, a speaking timer will be displayed on the screen by staff. If you are dialing in by phone and unable to see the screen, we will provide you with an audible warning when 30 seconds are remaining. You will be muted when your time has concluded. Lastly, this is a public forum. Today's meeting will be recorded and posted to the county website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. This concludes my introductory remarks. Mr. Rizzi, can you call the first item, please?
Madam Chair, Mr. Rizzi is having some problems with his computer, and it is basically restarted on him, so he is busy rebooting his computer. So in the meantime, I can take over until he.
Okay. Can you tell me who's speaking?
I'm sorry, it's just Cliff Hogan.
Okay, Cliff, go ahead.
So the first case is use permit V-11563-19-UP-1. Is a use permit request by Brian Adam, the owner, to permit an after-the-fact approval for a setback of 5 feet to the wall of an existing detached accessory building, 4.5 feet to the eave from the South Arlington Ridge Road right-of-way instead of 25 feet is required. The address of the property is 2335 South Meade Street.
Thank you, Mr. Hogan. Any questions for staff?
Madam Chair.
Mr. Owen?
I believe we received supplemental materials today from someone on this item.
Yes, we did.
Cliff, Mr. Hogan, do you have access to the supplemental materials? Or are you in a position to describe what they are?
Let's see if they're on BZA.
And also we should make sure that the applicant has seen the supplemental material.
Yeah, this is Brian Adam, the owner at 2335. Just want to make sure you guys are aware I am here.
All right.
Mr. Adam, did you see the email we got from Hamish Park today?
I don't know by name. I saw some attachments that Mr. Rizzi had sent over.
About the location of the property line with the public property?
Mr. Hogan, is this item on the chat? I think all these items are, is the supplemental material on the chat posted?
Madam Chair, I'm back.
Oh, Mr. Rizzi, thank you.
The supplemental material is available through the agenda that is linked in the chat, yes.
Great.
Applicants who had supplemental material also received emails with a link to that document as well today.
Great. Thank
you.
So,
Mr. Adam, we'll get back to you, but I hope you have access to this email.
Okay, when you say get back to me, what am I supposed to do?
When after we determine if there's any additional questions from staff, we'll let you make a presentation.
Okay, very good. Do I just stand by with,
yes,
or do I need to go back on mute?
Mute is fine. It'll only be a few minutes.
Okay, very good. Thank you.
Any other questions for staff?
I see Ms. Freshman has her hand raised.
Ms. Freshman.
Ms. Freshman is also on mute.
Sorry. Mr. Rizzi, I was interested in following up on Mr. Owen's question about distribution. I was interested in the supplemental that questions whether or not this the subject shed is on county property. Have you looked into that, and can you respond?
I can't respond other than that the applicant has submitted documents showing the shed to be on his property.
Thank you.
Any other questions for Mr. Rissy?
Madam Chair.
Mr. Owen?
So, Mr. Rissy, you have more experience reading plats than I do. In the packet, there are, the plats are included in our packet. So as I turn to that, that page, what I see is a lot named, numbered lot 27. And I see a triangle in the middle of the lot in a dotted line. And then I see an outline that goes all the way to the sidewalk with a curved tip. And the shed is in between the central triangle and the darker line that goes around with the curved tip. So is the property line as depicted in our materials, is that at the back of the sidewalk?
Correct. It would be the dark line that's on South Arlington Ridge Road at the back of the 4-foot concrete walk as described on the plat.
Okay, thank you.
The dash line on the plat indicates a 25-foot building restriction line, which is, as recorded, part of the deed, deed book 343, page 528.
So if the main building were newly constructed, parts of it would need a use permit to extend past the 25-foot mark as they do now, right?
It appears there are some portions that extend beyond that, correct?
Thank you.
Any other questions for staff?
Madam Chair?
Yes, Mr. Melnick.
So I have a question for Mr. Rizzi. So the building restriction line, this 25, but so this, do you know if that's in the nature of a restrictive covenant, like on the land records, as opposed to a zoning requirement?
I do believe the building restriction line is a type of restrictive covenant that goes along with the deed, hence the deed book and page reference, as opposed to the current setbacks of the zoning ordinance.
Do you know specifically if, I haven't seen a copy of that deed book and page document, but do you know if it covers things like this shed? Like, do you know if this shed goes against the provisions of that restrictive covenant mentioned in that deed book and page? Do you know that offhand?
I do not. I also have not seen any copies of that deed book and page reference. I will mention that building restriction lines are not uncommon on plats that we receive, and a lot of times don't match up with the current zoning restrictions.
Okay. Thanks.
Any other questions for Mr. Rizzi? Mr. Rizzi, do you feel we're on solid ground here with respect to building in this section? And let's say new building, since there is some existing.
If your question is, do I think that this shed is on his property? Yes, I think this shed is on his property.
Do you think it? But we don't know if it's possible. Is it possible that's in violation of a covenant?
I mean, that restricted, the article in the title that creates the building restriction line, in theory, could have anything in it, but there would be no way without reading that.
All right. Maybe the applicant can shed a little light on it. Mr. Adam, can you join us now? You can
Yes,
put
ma'am.
video.
Yes, ma'am.
Do you have video too?
I do not. No, ma'am.
Okay, that's fine. Anything you'd like to add to Mr. Rizzi's presentation?
Well, I mean, I could touch on, I've gone around the neighborhood. I've spoken with several different neighbors. I know that there was a deadline to submit letters from neighbors, I think a couple days ago, up till 5 o'clock. I spoke with several other neighbors after 5 o'clock, and they all said that they'd be willing to go around the entire neighborhood and get a full list of people that said they would not have any issue with the shed being there. This is one disgruntled guy who I live across the street from, who has now filed 4 or 5 different county complaints on me, and I've done nothing to this gentleman, but he, for whatever reason, seems to be out to get me. So every single person that I've talked to on my street has had absolutely no issue whatsoever with this. Also, I think one thing I think is worth noting, I think one of the reasons for these kind of different restrictions is because of safety and driving and obstruction of like being able to see. But this shed is located about 4 feet over a stone wall. It does not cause any kind of obstruction to traffic or cause any kind of obstruction to maybe pedestrians that are walking by. You know, and also if you look at my lot, it's kind of undetermined really what my backyard line is versus my side yard. And I believe the setbacks on those are different, if I remember correctly. It's really undefined because my lot is such a unique plat.
Mr. Adam, do you know where does Mr. Park live relative to you? Is he your street?
Mr. Park. Who is Mr. Park? Is that the gentleman who filed the complaint?
That appears to be Hamish Park.
I don't know who that gentleman is. I don't talk, the person who's filed complaints on me. We don't talk. We keep our distance. I don't know him by name at all.
So this may or may not.
He's the only one. He's the only one in my neighborhood who is not friendly to me and seems very disgruntled from the day I moved in.
So you're not sure if this is the same person that's filed other complaints?
I can't say for certain, no, ma'am.
Okay, thank you. All right, Mr. Rissy, we have no speakers on this.
We've had no one else sign up to speak on this matter.
Okay, is there anyone here present that did not sign up that wishes to speak? All right, sounds like no speakers. All right, any questions for the applicant? Otherwise, matters with the board.
So,
Mr. Owen? Yes.
I'm looking at an email dated September 10th from Mr. Adam to Stephen Rissy that says attached are 2 additional letters from neighbors. Are those the letters from Jennifer McDonough and Alex Littman?
Is that a question for me, sir?
Yes.
It is, yes, sir.
Okay. So Mr. Littman is one of the neighbors who's across Arlington Ridge Road and sees this across the street from their house.
That's correct. And I also went to the other neighbor directly behind me on Arlington Ridge and knocked on his door, but did not successfully get a hold of anybody. I waited for about 15 minutes.
Uh-huh. Okay.
I also attempted to knock on another neighbor's door on Mead Street, but did not get anybody to answer that door. I took photos of both properties with the address and provided those to Mr. Rissy as well.
Yeah, I think we see those photographs. When did you visit them?
Within the last week.
So you also submitted a hand-drawn landscape plan for the Arlington Ridge Road side of the shed?
Yes, sir.
Can you tell us about what you're proposing?
I'm proposing, I believe what I depicted there is 4 evergreen trees that, as you may know, will stay green year round. They grow about 3 feet a year. So in a matter of a couple of years, you wouldn't be able to see the shed whatsoever. But in the time being, I've also proposed to put bushes in between the evergreen trees. I think one of the concern is that the foundation of the shed shows more unfinished, exposed wood, and so I would put those bushes in there as well so that you would not be able to see any of that exposed foundation.
Okay. Thank you. I have no additional questions at this time, Madam Chair.
Thank you, Mr. Any other questions for the applicant. Mr. Rissy, the drawing that has been provided by the applicant, is that sufficient to be added into a condition?
I mean, that's really for the board to decide whether you're okay with that submission and requiring planting based on it.
But you feel that you could enforce, the condition could be enforced from this drawing?
I mean, if the condition is just that plantings be placed according to the drawing, I think that we can figure out how to enforce that, yes.
Okay, thank you.
I'm sure I note that
Ms.
Freshman has her
Freshman?
hand raised.
I see her.
Yes. This has been a very difficult project for me. I would suggest that even though it's not what professional submission that we're used to, if this is going to be approved, I would suggest that there definitely be a condition that the minimum amount of planting should be what's shown on the handwritten drawing, and that there's be a way of determining by a date certain, given that there's no construction involved, and it's only September, I don't see any reason why we can't at least require that material to go in as soon as possible, like within a month.
Okay. Mr. Adam, do you see a problem with that if that was a condition?
No, ma'am, I do not.
Okay. Oh, Ms. Clark is asking to come back in. Any other?
Madam Chair?
Mr. Melnick.
Yes, so I have a question for Mr. Rizzi. Could we condition the issuance then of the building permit on the, or condition the effectiveness of the approval on the landscaping? I understand no need for a building permit, but could we, just to trigger an inspection, I'm just trying to think of ways that we could trigger that. Or if we approve this with that condition, can the county then set, like the date where somebody will actually go out and inspect?
I think
Chair?
Mr. Rizzi, could you repeat your answer?
I was just going to say, I think that if you give us a date by which we should ensure that the landscaping is in place, we can do that.
Okay, thanks.
Madam Chair?
Mr. Owen?
I'm not making a motion because I still want feedback from the applicant. But I'm going to read out a proposed condition for the reaction of participants. The condition I'm considering is applicant agrees to install no later than October 20th, 2020, and to maintain for the duration of the use permit vegetative screening substantially consistent with the plan submitted to the Board of Zoning Appeals titled Back of House, such that the elements of the structure below the floor level are not visible from Arlington Ridge Road. So that's some possible condition language. Mr. Rissy, would that be sufficient to trigger an inspection by October 20th to see that it had been installed?
I think we can do that.
Mr. Adam, do you have any concerns with adding that as a condition to your use permit?
No, sir, I do not.
Ms. Freshman, do you have any reaction to that proposed language?
I think it's fine. As you know, I continue to be very disturbed by the structure in and of itself, but it will be a long time before it really is properly screened. But I think this is this needs to move on, and I think your proposal is is very good. Thank you.
Okay. Madam Chair, I'll just also note that even if we approve this, that doesn't necessarily extinguish the rights of some neighbor under established covenant to try to enforce the covenant.
Okay,
So that could still happen.
all right.
So I'm prepared to make a motion once we've closed the discussion.
Is there any further comment or question? Mr. Owen, please make a motion.
Madam Chair, in oh, wrong page.
Case number is at the top of the PowerPoint if you're looking for it.
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving approving the use permit V-11536-19-UP-1, subject to the conditions listed, as well as 2 additional conditions. One condition to be that, oh, no, subject to 1 additional condition, sorry. The condition I just read, the applicant agrees to install no later than October 20th, 2020, and to maintain for the duration of the use permit vegetative screening substantially consistent with the plan submitted to the Board of Zoning Appeals titled Back of House, such that the elements of the structure below floor level are not visible from Arlington Ridge Road. That's my motion.
Is there a second?
Second.
Thank you, Ms. Freshman. And Ms. Freshman,
Second.
thank you. Did you hear me? I got it. Ms. Freshman, can you hear me?
Yes.
Okay. Is there any other discussion? I just want to, just one comment I have, I will support the motion. If this is to the applicant, if he was ever thinking about repainting that shed, painting it brown or green would go a long way to solving the visibility problem. I don't want to make that a motion, but that's a suggestion, especially since it will take a while for the vegetation to grow, and it might be less obtrusive to passerbys and neighbors. Anything else?
Madam Chair, I think we may have lost one of our BZA members from the meeting.
I see 4.
Is Ms. Clark here?
Yeah, I see her.
I did lose power, but I'm back.
Okay.
All right. A motion has been made and seconded. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. Thank you, Mr. Adam.
Thank you.
Mr. Rissy, would you call the next case?
Yes. The next case is V-11554-20-UP-1. It is a use permit request by Colleen and Roger Lukin, the owners, to submit a street setback of 17 feet to the porch and 12.4 feet to the stormwater planter boxes instead of 21 feet to the porch and planter boxes as required from North Tuckahoe Street, regarding new front porch and stormwater planter boxes in the R6 zoning district on the premise known as 1804 North Tuckahoe Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Any questions for Mr. Rissy? All right. I see the Lukens are with us.
Yes, hello. Hello. Can you hear us?
Yes, we can. Is there anything that you would like to say on behalf of your application?
Well, we just wanted to thank the board for hearing our application again. We were before you last month with our application. And over the past month, we've worked on a couple of things regarding our application based on your feedback. One was that we completed, with Mr. Rizzi's help, all of the required signatures and notarization of the paperwork. And the other is we did a more thorough outreach to our neighbors, including sending certified letters to all of our adjoining neighbors and receiving an additional letter of support from one of our immediate neighbors.
Thank you. Any questions for the applicants? I don't think so. Just curious, since some of these were your next door neighbors, is there a reason you didn't knock on the door?
We're actually not we're not living in the home right now. We've moved out for a couple of months to be near our family, and as part of our construction, we've moved out. So we have been in contact with them, but we're not physical contact.
Thank you.
There's internal renovations going on inside the house too.
Got it. All right, thank you. The matters with the board.
Madam Chair,
Mr. Owen?
I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11554-20-UP-1, subject to the conditions listed, with an additional condition number 4 to read, the applicants will obtain a building permit to construct the structure permitted herein by September 16th, 2023, or this use permit will be null and void.
Okay, is there a second?
Second.
Thank you, Ms. Freshman. Any further discussion?
Madam Chair, I would just like to thank the applicants for their additional diligence in completing their application and the additional outreach to neighbors.
Agreed, much appreciated. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Your use permit is granted 5-0.
Thank you.
Very much.
Yeah.
All right. Mr. Rissy, will you call the next item, please?
Yes, the next item is case number V-11561-20-VA-1. It is a variance request by Jonathan and Michelle Van Laer. The owners submit a main building footprint of 36.1%, 2,398 square feet, instead of the 33% as required, regarding a front porch addition to an existing non-conforming one-family dwelling in the R6 zoning district, premise known as 433 North Manchester Street. Staff recommends that the board adopt the attached proposed resolution denying the variance. An alternative resolution has been provided should the BZA see fit to approve the variance as advertised.
Thank you, Mr. Rizzi. Questions for staff?
Madam Chair,
Mr. Melnick?
so just initially, I noticed a deficiency with the disclosure statement, and that is the name and address of the mortgage lender. Just so we know, who it is, do they have any kind of interest? So I just throw that out there because it's not listed.
Mr. Melnick, if I may respond to that, I've actually been advised that we do not need to require the name and address of the mortgage lender on the disclosure statement, as the mortgage can be sold between companies.
Okay. That's
one of the, Madam Chair,
Mr. Owen?
that's one of the things I hope we can revise on our disclosure form, because the current disclosure form does not make that clear.
Yes.
That the state law explicitly excludes normal commercial mortgage loans from the disclosure. And so if we revise the form, we could make that clearer.
Okay.
What my concern would be, because you're mentioning normal commercial lenders, but since this just says mortgage lender, I mean, this could be a neighbor giving a private loan. So just by the looks of this, we don't know if there's like a person that might have an interest, like a security interest in the property. So that was my concern.
Perhaps the applicants could tell us what kind of mortgage it is.
Okay, when we get to the applicant, we'll ask that question. You,
Okay.
hold off for a sec. Any other questions for staff? Mr. Rissy, I have one question. So the property is described as non-conforming. Is the sole non-conformity the right side setback?
I would need to review my staff report to answer that, Madam Chair.
Okay. Because the lot size and lot width are conforming.
It looks like it has a non-conforming right side setback as well.
That looks like that's the existing nonconformity, right?
Yes, Madam Chair.
Okay. All right.
I believe the coverage actually is also non-conforming for a structure that does not have a qualifying front porch.
So it's over coverage right now.
That is my understanding.
Okay. So those are the two non-conforming. Thank you. Any other questions for staff?
Madam Chair, because of the over coverage is caused by an addition that was built in 2012. Is that right?
That is my understanding, yes.
Is that addition still subject to any kind of enforcement action?
Not that I'm aware of.
Why not?
Because it was approved more than 60 days ago and was not challenged.
Okay, thank you. Go ahead.
By approved, you mean because a building permit was issued?
Correct.
Okay.
Madam Chair,
Mr. Owen.
one of the things that we have to evaluate in a variance application is whether or not a claimed hardship was caused by the applicant. And so it appears that part of the case the applicant might be making on this property is that they have a hardship because they can't build a front porch because they're already over the limit. And that was caused by the 2012 edition. So it has long confused me whether, I mean, this is a different owner, but of the same parcel than built the 2012 edition. And so is it staff's view that if the property hadn't been sold since 2012, that a variance would also be prohibited on the grounds that the applicant had caused the hardship? But since there was a sale, the new applicant gets a clean slate and that no longer applies to them? That just selling the property gets rid of that problem? Is that staff's understanding of Virginia law?
I would say that it certainly is not the case that it is this applicant's creation of the hardship for something that happened before they owned the property. But I would guess, and I, can't say in every circumstance, but that if it had not been sold and it was the owner who had built the porch, that may not hold. Now, there may be reasons why it could. They may have been reliant on someone else to submit the documents, and they may not have known. I can't say for certain that that's the way it would always go, but that does seem likely.
Okay.
May I follow up, Mr. Owen?
By all means.
How is this different if a developer had built a house that totally maxed out coverage? Is there any difference in as far as practically how we would proceed?
Practically, whether it be a former homeowner or developer, I don't see a difference.
I mean, simply the house has maxed out lot coverage. That's a fact, and how that came about is that Do we think that's relevant?
If your question is whether it differs because one was a homeowner and one was just a developer, I do not think so. I would also say that the issue here is not lot coverage, just to be clear. We are talking about the main building footprint.
True. Correct. Okay.
So
Thank you.
I'll just say that remains just a general point of confusion for me about our rules of the road in Virginia for variances. Because as you point out, Madam Chair, it may create an incentive for really cynical behavior on the part of developers. There was no developer here, I think, but a developer could even build over the lot coverage, right? Sell it to somebody else, or whatever. Create all sorts of hardships and say, hey, good news. When you buy this, you get a clean slate. So I know that I could never apply for a variance, but I'll tell you, you can apply for a variance because I did it and now I'm selling it to you. And I don't understand. It doesn't make sense to me that Virginia law would work that way, but I do think that it is unclear to me, even after some of my own extracurricular research, whether or not that's the rule in Virginia. But, that's not exactly what's portrayed here, but I just thought I would explore it a little bit before we heard the case. Thank you.
Thank you, Mr. Owen. Mrs. Freshman?
I agree with the thrust of the discussion, and I would suggest that it would be really useful for staff to reach out to the zoning administrator and or the county attorney and give us some guidance on that, because we have certainly had applications where a builder has maxed out, and then an unsuspecting buyer has come in to try to put in some sort of a modest stairway or something and not been able to do it. So I think regardless of who did it in this case, we are assuming there was a building permit and therefore permission. We don't actually know that either. But it would be helpful, because I think more and more this may come up and it is confusing. Thank you.
Thank you, Ms. Freshman. Any other questions for staff? Okay, is the applicant with us, I believe? I think I saw him a minute ago.
Hi, good evening. I'm trying to turn my camera on. This is John Van Laer. I regret my wife's teaching tonight, so she couldn't be here. Thank you for the time to speak. Sure. I can address some of the discussion that came up just in the last few minutes that I heard. The history here that I understand is that the addition was put on in 2 phases, ending in 2012. By the previous owners with the general contractor. I don't know for certain whether they had a permit, but I assume that they did, but I don't know for sure. So they just moved a couple blocks away onto North Arlington Mill or on 9th Street, I think, to build up on a house that they preferred, and sold this house to us. We were unaware that we were already at our footprint when we made these plans. Just honestly operating in good faith to try and put a front porch on the house. As you can see in the picture, we're at that pipe stem at the end of Manchester. It's a lot of social activity happening right there in front of our house all the time. And including that pipe stem sort of becomes the hub for neighborhood parties, block parties, if you will, frequently. And so we want the front porch to be sort of more aligned with our neighbors. All our neighbors support this. And so we're simply asking to build on this modest front porch and just defer to your better judgments otherwise. But that was all I had, except to say, to address Mr. Melnick's question, we are financing this through a HELOC through our bank. And I think that would be all pending your questions. Thanks for the time.
All right. Thank you, Mr. Van Laer. So, question for Mr. Rissy. Could this porch be smaller and meet the building footprint?
No, Madam Chair. In the staff report, we lay out that the current structure is within
Already.
1 foot
Right.
of the size that would be allowed if they had the front porch, and so they can't build a front porch of less than 1 foot, get the qualifying bonus. So it could not be smaller and get the bonus.
To be very small.
Small enough that it wouldn't get the bonus.
All right. Any other discussion, questions for staff or the applicant?
Madam Chair,
Mr. Melnick.
so I do have, at this point, I would like to say that, as is sometimes the case with variance applications, I just don't see this falling into like the criteria for granting the variance, the unreasonably restricting the use of the property, the hardship, because the deck was put on after the ordinance, governing the main building footprint. But I'm just not seeing, it meeting that. And we, have to think about precedent, like you're saying about builders, developing to the max. We don't want to set a bad precedent in this sort of case. But I'm just not seeing an exception. And what the homeowner can do, although, it may be costly, is just rearrange the parts of the house, maybe make the deck smaller, do something like that, just to allow for this building footprint that they want to have, and have a front porch. So, but I just don't see that it's meeting the requirements. So that's my position on it.
Thank you, Mr. Melnick. Any other comments? Ms. Freshman?
I agree with Mr. Melnick's conclusions. I think it's really unfortunate, but there's an awful lot on this lot already. I'm very sympathetic to front porches, and I think it would probably be a very nice addition to the house, but it far exceeds what's permitted. And so unless they can make adjustments to some of the other parts of the property in order for it to be at least very, very close to what the requirement is. Unfortunately, I think they're caught in a bind, and while it wasn't of their own choosing, that's unfortunately not consideration. Thank you.
Thank you, Ms. Freshman.
So I'm prepared to make a motion.
Mr. Melnick.
Okay, so in case Z1156120ZA1, I move that the Arlington County Board of Zoning Appeals denies the variance in that case, as stated on the resolution of denial.
Second.
Motion made by Mr. Melnick and seconded by Ms. Freshman to deny the variance. Any further discussion?
Madam Chair, I agree with Mr. Melnick's reasoning.
Thank you. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to deny the variance has carried. Mr. Van Laer, you heard our comments about the unfortunate situation you have here and your option to possibly rearrange some of your coverage so that you can prioritize the front porches if that's something you want to do down the road.
Thank you, Mr. Melnick already expressed why that won't be happening. It's far too expensive to even consider, but thank you for your vote.
Okay, thank you very much. Mr. Rissy, could you call the next item?
The next item is case number V-11561-20-UP-1 is a use permit request by Jonathan and Michelle Van Laer, the owners, to permit a street setback of 18.4 feet to the porch, 17.2 feet to the porch eve from North Manchester Street instead of 21 feet to the porch, 19.5 feet to the porch eve as required, regarding a front porch addition to an existing non-conforming one-family dwelling in the R6 zoning district on the premise known as 433 North Manchester Street. Staff had recommended that the board adopt the attached proposed resolution granting the use permit request with conditions. However, staff has also provided an alternative if the board were to deny the variance, which they did recently.
Okay, I see the alternate resolution. Is there a motion?
Madam Chair,
Ms. Freshman?
I move that the Board of Zoning Appeals in the case V.
Ms. Freshman? I'm sorry.
Sorry?
I think the applicant, I think I should give the applicant an opportunity to speak if he wishes.
Okay.
Before we move on, and I saw him coming in and out of the meeting.
Yes, I'm here. I've returned, but I'm afraid I missed a moment. You were going over the alternate variance.
So
option?
So your application had two parts to it. One was a variance for the building footprint, and then the second was a use permit.
That's
that
right.
should the variance be approved, whether the use permit would be approved.
That's right.
And it looks like approving the use permit was contingent on us granting the variance. And so we are looking at that right now. I don't know, is there anything else you want to add at this point?
We're going to do other work inside the house, but and I don't know if the use permit applies to that at all, but otherwise, no.
Okay. Mr. Rissy, am I correct that the use permit is entirely related to the porch?
Correct, Madam Chair.
So, Ms. Freshman, would you like to
Madam Chair?
Yes, Mr. Owen.
So I'll just say that I actually thought that the use permit standing alone was a sympathetic prospect. I agree with the applicant that the front porch as they propose it would be compatible with the neighborhood. And so I just want to put absolutely clear on the record for this item that the applicant does not wish to have a deferral to consider a redesign of other parts of the house to make this possible. There's no point in pursuing this at all, because without the variance, you don't want to pursue the front porch anymore. Is that right?
That's right.
Okay, thank you.
All right, now, Ms. Freshman, I'm sorry.
Thank you. In the matter of V-11561-20-UP1, I move that the Board of Zoning Appeals deny the special use permit.
Is there a
I'll
second?
second.
Ms. Clark seconds the motion. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick? Ms. Clark?
Aye.
Chair votes aye. The motion to deny the use permit has been approved. 5-0. That concludes the item. Thank you, Mr. Van Laer. Mr. Rissy, would you call the next item?
The next item is case number V-11562-20-UP-1. There's a use permit request by Kathleen and Michael LaPerry, the owners, to permit a street setback of 18.1 feet to the porch, 16 feet to the porch eve instead of 21 feet to the porch, 19.5 feet to the porch eve as required from 23rd Street South and South Buchanan Street, regarding a new front porch addition on an existing one-family non-conforming dwelling on a corner lot in the R6 zoning district on the premise known as 4800 23rd Street South. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions, and I would like to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Mr. Rissy. Any questions for staff? Ms. Freshman.
Yes, I'm just curious, when I was looking at the site, which is really quite a lovely site, actually, it appeared that there's a large addition on the back. It didn't look as if the entire house was original. And given that it's the setback from Buchanan, I wondered if that's the case, why the non-conforming status wouldn't have been brought up before.
Yeah, but why does that in 94?
I don't think it's overwhelmingly critical. I was just curious, because typically when we have a non-conforming of any sort, a change raises a red flag.
And there's been no previous BZA actions.
No.
Why is it non-conforming?
Maybe the applicants know, but I don't know.
I'm sorry, Ms. Freshman, I'm having a difficult time. I'm looking at the plat and it doesn't appear to me that the rear addition is non-conforming. It looks to be set in 1 foot from the main structure, which has a setback of 24 feet from Buchanan Street.
So if it had been added on by deviating 1 foot, that made the addition legal, but why isn't the original house still non-conforming? It doesn't suddenly make the whole house conforming, does it?
No.
I'm just curious as to why there didn't have to be an action for that application, because now this matter we're considering is because it's non-conforming.
Well, no, the reason you're considering the application today is because the structure that they're proposing would not meet the current regulations.
Okay, but the staff report does say it's a non-conforming 24 feet from South Buchanan.
The existing structure is not the rear addition.
Right.
So they can do an addition that meets the regulations of the ordinance. It's just this one wouldn't, which is why this comes and the rear addition didn't. But
they can do it. They can do a conforming addition to a non-conforming dwelling and not have any issues of the original being non-conforming.
Correct.
Okay, it seems like we do have cases where the very fact that the house is non-conforming is the reason they're before us. So I find that very confusing, but I won't dwell on it.
It comes out of our Article 16, which, to be fair, is very particular to the type of building and zoning district. There are certain structures, one of them here tonight, that doesn't have the same abilities that this structure did to add that rear addition without needing BZA approval.
Okay. Thank you.
Thank you, Ms. Freshman. I think that's a very interesting question you asked about adding a conforming addition to a non-conforming building. Is the applicant here this evening?
Yeah.
Could you turn on your video?
Stand by.
If you have it.
Can you see us now?
Yes, we can. Good evening.
Good evening. I'm Mike LaPeris, my wife Kathy.
Hello.
And we were unaware that our dwelling was non-conforming. So
how long have you lived there?
Since 1989. The rear addition was built in 1994 to specification, and we knew that it was conforming. We just didn't realize that our original house from 1948 was non-conforming. We obviously would like this front porch. It's very important to us, and there's plenty of room along the side, the front, and even in the back with the addition. Our neighbors behind us are at least 25 feet away from us. And on the front, after the porch is built, we would still have at least 15 to 20 feet to the sidewalk. And again, we were just unaware. We were unaware that that this would be a problem. All our neighbors have signed off on this. We have at least 3 front porches around us from various neighbors, and the neighborhood, I think, would be enhanced by our front porch.
Thank you. Any questions for the applicant?
Madam Chair.
Mr. Owen.
Yes, I did not see written feedback from the neighbor across the street at 2301 South Buchanan Street. That's the corner lot across Buchanan Street from you. Can you talk, either point to their feedback or let me know what your outreach was to them?
His name is Steve, and he lives behind us, and he owns that house at 2301.
He owns the huge, and I mean huge house across the street
On Buchanan, and he rents it out. And he already signed a note. His name is Steve Baconi with a V.
So he owns 2 of the houses that are neighboring to you.
Yes, sir.
That's correct.
Okay, great.
That's good.
All right, I have no other questions.
All right, discussion, any other questions for the applicant? Or discussions with the board?
Madam Chair.
Mr. Owen.
I agree with the applicants that this project would make the structure even more compatible with the neighborhood than it is now. It would be, seems like it would be a positive all around. So I support it.
Is that a motion?
Sure. I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11562-20-UP-1, subject to the conditions listed.
Second, Ms. Freshman?
Oh, I'm sorry, with one additional condition, with the 3-year time limit for a building permit, that identical to the one we discussed earlier.
Second.
Thank you. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Use permit is granted on a vote of 5-0.
Thank you.
Enjoy your lovely new porch.
Thank you very much.
All right, thank you. Have a good evening.
You too. Mr. Rissy, will you call the next item?
The next item is case number V-11563-20-VA-1. It is a variance request by Zach Pride, the owner, to permit a setback of 8.3 feet to the left property line instead of 10 feet as required, and to permit addition that is greater than 50% of the floor area contained in the existing building as of July 15th, 1950, regarding a new 2-story rear addition in the RA18 zoning district on the premise known as 327 South Wayne Street. Staff recommends that the board adopt the attached proposed resolution approving the variance with conditions.
Madam Chair,
Mr. Owen?
I have some questions for staff.
Go ahead.
This variance is needed in part because the addition would exceed 50% of the footprint of the original structure. Is that right?
Correct.
And what is staff's analysis for why a variance is appropriate to violate that zoning requirement in this case?
Because this structure, had it been built larger in 1950, would not need a variance to do the addition of the size there. In my staff report, I mentioned that they're, I think, within 120 square feet. If this house had been built with a basement, they would be within 120 square feet of the size necessary to build this addition by right. So it is because of the size of the structure that was placed on the lot prior to the enactment of the zoning ordinance prior to July 15th, 1950, that they need this variance.
What is the purpose of the 50% limitation?
I can't speak to the purpose of it. Zoning just has to enforce the zoning ordinance as it's written.
But the Board of Zoning Appeals is required to examine whether or not a variance would be consistent or inconsistent with the county policies. So if the county has zoning policies that the 50% limit supports, it's our responsibility to know what they are. For example, we need to examine whether or not the applicant's proposal furthers the purpose or undermines the purpose on this particular parcel. Is there anything unique about this applicant's proposal or the applicant's parcel that makes the purpose of the 50% limitation more unreasonable than a typical parcel to which the 50% limitation would apply?
I think the thing that makes this parcel unique is that the 50% limitation does not exist on most parcels in Arlington County.
How many other parcels has this limit?
I can't say exactly.
Didn't you say in the staff report?
In the staff report, I mentioned how many two-family dwellings were on parcels in the RA zoning district, I believe. But of that, I can't say how many have a conforming lot size and not. So some subsection of that, including this parcel, have this limitation placed on them. But it would not be even all those that staff mentioned in the staff report.
I see. Okay. All right. I have another set of questions. In recent years, the County Board and Planning Commission have repeatedly revisited and loosened zoning ordinance restrictions on two-family structures in the county, including most recently Saturday. However, during these reviews, the County Board and Planning Commission have not disturbed the 50% limitation. Is the 50% limitation more difficult to analyze or modify legislatively than the other two-family ordinance requirements that have recently been reviewed and amended?
Again, I don't know that I can answer that question for the board and the Planning Commission.
Is there a policy reason that you're aware of why no one on the county staff, the Planning Commission, or the County Board have proposed amending or eliminating the 50% limitation?
I can say that I cannot say that no one on staff has proposed that, but all I can say is it has not been done to date.
So to date, the manager has not proposed changing it, at least. Okay. Okay. And then I have another set of questions that don't have anything to do with the 50% requirement, but I'll hold them until we do more work on this. Thank you.
So any other questions for Mr. Rizzi? So just to follow up on Mr. Owen's line of questioning, do we, the number in the staff report is not the number of parcels that would be in a similar condition?
No, Madam Chair. That is just a number that staff can give you as to meeting a certain condition. What staff can't say is how many of those parcels would actually need a variance because their lot size is non-conforming. Staff just doesn't have the numbers to analyze that at present.
But is it something that can be analyzed?
I mean, in theory, anything could be analyzed, but it would take looking at plats for each of the parcels that would be in this list, and I don't know that it would be easily analyzable.
So I too am having a little trouble with simply waiving the 50%, simply because of the size of the existing structure. I'm not really following the logic of that. But I'll try to wrap my head around that.
Madam Chair.
Mr. Melnick.
So I think if I'm understanding it correctly, it's because we started out with such a small dwelling that it's a hardship. You know, just the smallness of it's a hardship. Is that right, Mr. Rizzi? Is that what you're saying?
I think that's a good summary. Just as the lot size, the smallness of the lot size can be a hardship, so too in this case, the smallness of the structure on the lot prior to the adoption of the zoning ordinance is the hardship now for the applicant.
Have we ever used this logic before? That the dwelling actually has a bearing on a variance?
I have used it before. I have recommended a number of variances based on the structure, because the criteria isn't limited just to the parcel itself. It also takes into account or the improvements thereon, which is the structures on the lot. So I've used this argument a number of times. I don't always win, but
Madam Chair,
you're free to disagree if you do so.
Thank you. Mr. Owen.
I mean, without having a consensus on what the purpose of the 50% limitation is, it's difficult to do this analysis, because it's possible that the reason the county board imposes this requirement is that they want to keep a diversity of sizes of these kinds of dwellings, that they intentionally want to have to preserve the current number of tiny little cottage sized houses and maintain that as part of the housing stock. Or they think that's an important historical feature that needs to be maintained, or you know, or that's important to the character of certain neighborhoods, that the smallest houses remain relatively small. Maybe they didn't have any of those purposes, but it's quite possible that they did. You know, we do have the benefit that just last Saturday, the county board approved, I think, on the consent agenda without discussion. But the planning commission considered at length for over an hour a closely related zoning ordinance amendment. And during that discussion, there absolutely was discussion by some planning commissioners about the problems of allowing the very smallest of these kinds of houses to be overbuilt and to lose this part of our housing stock. Now, I may agree with that or I may disagree with that, but I'm not on the planning commission and I'm not on the county board. I'm on the Board of Zoning Appeals. My job is to try to figure out why this 50% requirement is here and keep enforcing it until they change it. So it seems to me that in fact, as far as I can tell, the 50% requirement is very much meant for this kind of situation. I also note that in the county board report for last Saturday's action, they said in considering the scope for this study, meaning the study of the other relief from zoning restrictions, the staff has identified 432 two-family dwellings that are located in RA districts in the county. Of these 232 dwellings, 149 are located in RA districts, and 283 are located in RA districts. In the HCD areas, 283 are located in RA districts in other parts of the county. I mean, those numbers are all smaller than the number provided in the staff report describing the scope of, potentially affected parcels in this case. So I feel like, you know, if we're trying to figure out whether or not this is an area the planning commission and the county board would like to make decisions in, or whether or not this is something that's a forgotten appendix to the zoning ordinance that's out of date, or that they didn't realize that a house like this might exist when they wrote it or when they didn't change it. I don't think that doesn't seem fair to say. It seems fair to say that the county board and planning commission have very closely been examining this part of the code, and they definitely have not changed this 50% requirement, even though they are fully aware that houses as small as this exist. So it's hard for me to cross the bridge, but we're still in staff questions that I know the applicant hasn't even had a chance to speak yet.
Mr. Owen, do you have anything else you want to ask about regarding this?
Not at this point.
I had a technical question on the advertisement regarding the left side of the property. Mr. Rissy, am I reading this wrong? Which side of the property is being developed?
As you look at it, the addition would be on the left of the subject property, sharing the sharing the party wall.
I'm sorry.
It's on the right.
I'm
The addition's on the left. The 8.3 foot setback is from the right side property line, correct?
So if you look at the subject line, am I reading that correctly? That should say right?
That should say right.
Is that a deficiency in the advertisement?
I would say so.
Okay.
All right. I think we should hear from the applicant. Mr. Pride, are you here?
I'm here. I'm his contractor representative. I'm
All right.
Yeah.
I see. Yeah. I saw you for a moment.
Oh, we're here. Sorry. Hello.
All right. Okay. So could you? It's Mr. Pride.
No. Yes.
Mr. and Mrs. Pride.
Mr. and Mrs. Pride. Okay, good. And your agent?
Yes. Yes, I'm his agent.
Okay, the contract, Mr. Mohammadi?
That's right.
Okay, thank you. Anything you'd like to tell us about your application?
Sure. Well, when I met Mr. Pride and his wife to give him a price for addition and all that stuff, usually we go and check with zoning based on what the setback and the property footprint is. And that time his neighbor has like more than 50%. We thought, okay, they did it. We promised him, okay, we can do it too. So I'd have one of my employees check with the zoning that what is the requirement for that lot. They just told us setback. We actually sent a plan twice with the comment come back to us to the county. Then with like 2.5 months after doing plan and all that, they told us that we have to go through special permitting, which as Mr. Reese said, I didn't think there's a 50% on that. So you can only do 50% of the footprint or the house. So right now we're trying to give him a larger place because his family, his mother-in-law, they're moving in, and father-in-law. And that house basically is 400 square feet, one floor. And if you go inside, it's basically like there's no room for the kitchen. I understand. I've heard that there is a reason, probably zoning, they don't allow more than 50%. But as he said, they might forgot because the staff didn't tell us that there is 50%, and we already had a contract with them. And basically, I'm doing this, you know, as a non-chargeable thing to my customer too. And because I promised them I get the permit. So here we are. We submit all the document, and as you see, there's a neighbor on the right side of the house. They have more than 50% addition on their property. So I think based on that, and the other one, there's another one, 2 blocks up, and I thought, you know, it would be nice to get it granted for the permit for the building. Number one, we have like people already got permit. I think it shouldn't be, you know, for us should be the same. Then the other thing is the house is really small. I mean, you know, it's just too small. I understand. You just and Arlington is growing. You have to understand people who are moving to Arlington or they are living in Arlington, they pretty much want to have a little of a luxury house to be living comfortable. Even if the poor one in Arlington, they want to have a better life. So just this is what I'm guessing. It should be kind of like an advantage to give us a grant to do that. That's basically it. If Mr. Zach has anything to say, you're welcome to say.
Yeah, sure. Thank you. Thank you for hearing us tonight, for your time. We basically, we want to start a family. We know that in order to start a family, that we need space. And right now, it's just barely enough room for 2 people. I know that this particular community was, I'm in the Army, and I know that back in the 40s, that when the Pentagon became bigger and they needed more federal workers, they developed this particular neighborhood for that reason, for transient workers. So it wasn't really meant for big family dwelling. And I understood that when I moved in, but I also knew that there were 3 other additions like this, even bigger, like you know, Mr. Muhammad says, they were even bigger, and that wasn't my goal. I just wanted a place big enough for me and my wife and, you know, our 2 future kids to be, so that we move around and have just a little bit of room. Obviously, even with the proposed section, it's not as big as the other places that are on the street alone. So
thank you. Mr. Hamady, you mentioned that you feel that there's other parcels, other units that have received 50% increases in their size?
Yes, if you look at the picture you have on the right side, that's one. That's more than 50%.
But do we know what are you looking right at the right side neighbors?
Yes.
Okay. Do we know what they started out at? I know the building definitely looks bigger, but the requirement is 50% of existing. So you really have to start with what was existing.
The existing 16 by 25. We submit for 16 by 22 for the addition for Mr. Pride. Versus 16, 12 and a half. No, yeah.
Okay. Any other questions for the applicants?
Madam Chair.
Mr. Owen?
If it's for either the applicant or the contractor, is your house smaller than the other houses on Wayne Street or on Beach Street that have not yet had additions? So I see on the what we call the tax map, the map looks like this. So I'm seeing that most of the houses on Wayne Street and Beach Street on your block, many have big additions, but most don't. And so my question is do you know if your house is smaller or the same size as the other houses that don't yet have additions?
Certainly, if you look at the one immediately well,
So for example, 401 and 403 Wayne Street, 409 and 411 Wayne Street,
Or if you look at
312 and 314 Beach Street.
Beach Street, yeah, they look also very small.
So
Yeah, but
it just, if you happen to know, you might not know. It's not something I would expect you to know, but do you happen to know how the size of your house compares to those?
I do know that my neighbor, the next door neighbor that has their addition, they are the next house, the dwelling. They have more space with their original housing just because of how the roof is made.
Yeah.
And I'm not sure if they have a basement or not, but I do know that because I've been over there. I used to know the couple that lived there before they sold the house.
Yeah.
But I have one of the smaller homes. We have one of the smaller homes on the blocks, to my knowledge, because that's just how it's made with the roof, and it's just a smaller place that I've noticed. Now, how much smaller, I'm not sure.
Okay.
And I haven't been in all the homes, so I don't want to do that. I mean, I should have did my research, but
This is an especially technical question, so even the answer you just gave was quite helpful. Thank you for that.
Okay. Yeah.
Any other questions for the applicant or his representative? All right. So, you know, there's basically two things. There's their policy question, and then there's the advertising question. And I believe that Mr. Rizzi, is that correct? Or
Sorry, didn't hear the full question there.
Will we need to defer this or re-advertise it?
I think that's likely.
All right.
Unless you guys are going to deny it, in which case there is no point to a deferral.
I see your point.
So I'm sorry, I'm missing something with the advertisement. What do you mean by advertisement?
So, do you have a copy of your report? Have you seen it? There's an error in the way.
I have it. I didn't. I'm sorry.
There's an error in the way it was advertised.
Oh, so because
not your error.
It wasn't your fault.
I see.
It was.
I see. Okay.
It was a
I was
staff.
going to say that did you get all the neighbors' approval? Okay.
Yeah.
So most people knew about it. I don't know if that's what you mean by advertisement. So.
Yeah.
No, I'm sorry. It's the legal advertisement.
Okay. I don't know anything about that.
It's a state law requirement that we had to put in the newspaper what exactly you were requesting. And it looks like it was mistranscribed into the newspaper.
But I've got an email that has been sent, they advertised from Mr. Reese, didn't I? I got an email, I think it was probably like 4 weeks ago, or there might be some error there. So.
Yeah, the error is the error is how it was portrayed to the newspaper, to the public. There's just one word off.
Mm-hmm.
So,
Madam Chair, I've actually been told by other staff present that as long as the address are correct, the reference to the side does not need to be re-advertised, at least for items that go to the county board.
so if we adopted one of the proposed resolutions, it would be wrong.
Yes, but you can change the word left to right.
I don't know how that applies to us. If Miss Freshman.
I generally am sympathetic to the application. I think that if there's any confusion about the advertising, then I would recommend a deferral to address that, just to be certain, since this is not something that goes to the county board. And in the meantime, I think there could be some research into the relative size of the built dwellings in this block on both streets. I think that I understand what Mr. Owen was saying about the two-family dwellings and about trying to keep variety of housing stock, but we also encourage families and we encourage a lot of things. And so I'd be in favor of deferral for that reason, to do a little more research, but also to correct the advertising. But with the understanding that while there may be a 50% rule that applies here, I'm much more sympathetic to the application.
Thank you, Ms. Freshman.
Madam Chair?
Mr. Melnick.
I too agree with what Mr. Owen was saying, just about really, just trying to look into this policy, because that makes a lot of sense what he was saying, about the diverse size of places, just, because, it is the 50% has to do with the original size, and they haven't done anything to it. So I think that's very worthwhile to look into as a policy of Arlington. What is it? Even look back as to when it was originally passed, see if there's anything about it there. But I think that's really valid.
I support the idea of a deferral. It doesn't guarantee that we're going to make an approval down the road, but it does give an opportunity to make sure the advertisement is correct so that the applicant doesn't run into any other problems down the road, and to look at this policy question. However, it also would require some research. And I don't know how long that kind of research takes to determine sort of the scope of, because I think what we're looking at is the scope of the problem sufficiently large that it should have a board action to clarify, or let's put it this way, if there's no interest in loosening the standard, we would be bound by it, I think. Go ahead, Mr. Rossi.
Madam Chair, I have to interject there. I would say that the board was fully aware of this being in the ordinance, and they chose not to relieve it when they relieved the prior section in Article 16. The remedy is to the Board of Zoning Appeals for people to get variances, which, by the looks of the other additions on the street, people have historically been able to do. The applicant has mentioned that his house is built without a basement, which is different than the direct neighbors. Staff is not going to be able to analyze how many of the structures in the surrounding areas have such basements or additional square footage outside of the footprint of the house, which we may or may not be able to determine based on whether a plat was submitted. Staff is very limited in the type of research that I think you're asking us to do here.
Mr. Rossi, you conclude that the board took no action on this because they wanted the BZA to handle this, or did the board not take any action because they were happy to leave that requirement in place?
Madam Chair, I can't speak to why the board did or did not do anything. I will also mention that this section of the ordinance was adopted in 1950 and has not been updated since. I will say that the Board of Zoning Appeals is the body to which an applicant can apply for relief from this section. And if the board intended for you not to be able to modify that, they would take that authority away.
Well, this is parallel to what we just went through, where we concluded it was not appropriate for a variance because it was a situation applicable to many sites, and therefore it was bumped up to the board for review. I'm not sure how this is different.
Well, the board looked at those conditions and decided that those properties were eligible to do additions without a variance, except in certain situations. And this is one of those situations where they will still be required.
Mr. Owen?
Thank you. First, with regard to the advertisement, I found the code section that applies to us. And it says that each such advertisement shall contain a descriptive summary of the proposed action and a reference to the place or places within the locality where copies of the proposed plans, ordinances, and amendments may be examined. So I think the descriptive summary, as opposed to just the address of the activity, seems explicitly required by statute. So I definitely would support re-advertisement. With regard to the discussion you were just having with Mr. Rissy, I guess I would want to advise Mr. Pride, as you might be discerning, this is an ongoing discussion we're having over a course of years. And on in at least 2 prior rounds, the Board of Zoning Appeals has denied variances to duplex owners like yourselves. They went to the county board and said, the Board of Zoning Appeals said this is a general law that applies to everyone. Should you change it? And 2 times now, the county board has said, we'll change the whole law to make this allowed now. It's a new county policy we should change. So I don't know why, apparently no one, knows why they didn't yet do this with the 50% requirement. But I know you're a military family, so you might not find it as easy as some others to do all that.
We actually,
I just want to sort of, I'm sorry, go ahead.
We don't PCS, so that's why I wanted to make this my permanent residence. So this will be my last residence.
Oh, well, that'd be great.
Yeah.
Good. It'd be nice to have you in Arlington. So, but anyway, I just wanted to let you know that part of the whole discussion we're having here is we're just trying to figure out whose responsibility it is to say yes or no to you. Two rounds ago, over the course of the last 3 years, we've said it shouldn't be our responsibility. And as you heard, Mr. Rissy was speculating that the county board thought it should be our responsibility. And that's really the argument we're having. It's not whether to provide you with no option or even whether or not it's reasonable or unreasonable on your parcel. It's whether or not, when it's reasonable, but it applies to other people, which body is the right one to do it. So that's the challenge we're facing.
I would like to get this done, hopefully, before we have the baby. before we have like a lot of construction. I want to thank you for that explanation, sir.
Any other comments or discussions? Mr. Rissy, to re-advertise this, when would the hearing date be?
October 14th.
All right. Is there a motion in any direction here? I will move that the Board of Zoning Appeals defer variance V-11563-20-VA-1 to the October 14th BZA hearing.
Second.
Madam Chair.
Mr. Owen.
I would ask unanimous consent that the motion include a rationale or rationales. I'd ask unanimous consent that one rationale for the deferral would be to re-advertise the correct advertisement.
All right.
And I'd ask unanimous consent that the other rationale be to provide an opportunity, if staff is able, to identify some of the policy rationale for the 50% requirement, and or the number of parcels in Arlington, similar parcels in Arlington that have a smaller original building size.
Right.
I'm not saying that staff has promised to do either of those things, but that part of the deferral is to see if they can.
To bolster their argument.
I have a question. So, Mr. Allen, when you say to see if it has a smaller building size, you know, that seems, is there anything you could, you know, like, that seems pretty broad, you know, compared to this?
Mr. Melnick, I struggled with how to frame that. You know, it sounds to me, when I asked Mr. Rissy earlier, what makes this one different from all the 500 others? His answer was it's small, it's got a smaller original size. So that was why I picked that to follow up on. But I would certainly be open to alternatives.
Yeah, maybe smaller. You know, I see the trouble in trying to say that, like smaller. Then how do you say compared to what? Definitely.
I'm just trying to stay within the metes and bounds of staff's proffered explanation, which is that this house is just as a matter of raw square footage, too small to not allow it to expand more than 50%. That's my understanding of Mr. Rissy's argument.
Yeah.
Maybe there's other arguments that he could or should have made, but that's the one he did make. So that's the one I wanted more information from.
Madam Chair?
Mr. Miller.
Could we say something like comparably sized dwellings? You know, something like that? You know, that they're to look at comparably sized?
I'm not sure that if I got an answer about comparably sized, it would help me make this decision better. Because the thing that makes me want to say no to this variance is that there's lots of, you know, it seems similar to a lot of other parcels. And so we already know the denominator, 500 and some odd possible properties. And so if there were only 4 of them in the whole county that were smaller than this one, then it seems like it might be more reasonable to agree with Mr. Rissy that this is so small to start with, we should just grant the variance. But if it came back and there were 300 that were smaller than this one, then we would know that's too many. So it seemed to me that knowing how many are smaller, you know, but we could ask both, right? Similar and or smaller. Well, why not ask both questions? I think there's a good chance we'll get neither answer back. But why not ask more questions rather than fewer?
That sounds fine.
All right. Well, asking unanimous consent to modify the unanimous consent. Ms. Freshman?
Yes, I'll support the deferral, and I recognize that given that we're talking about just a couple of weeks, it's not realistic for the staff to be asked to do what sounds like a fairly intensive research project. But they've heard the dialogue, they've heard the concerns that have been raised, and to the extent that they can come up with what might in another report be a table of comparables, I don't think a countywide or even necessarily this whole mega block is fair to expect them to do in the time frame. Personally, I do think it's our place as a Board of Zoning Appeals to allow for exceptions, and I would agree with the staff report and support it. But if there aren't 3 votes for that, then I'll support the deferral, and we can correct the advertising in the, while we're at it. But I would prefer I'd prefer just to approve it.
Well, we have a motion on the floor right now to defer. Any further discussion? I will call the roll. Mr. Owen?
I'd like to.
Sorry.
Oh, I wanted to know if I could add one more thing, or just ask a question before the roll is called. The precedent of the other homes with the same additions, what does that? How does that compare to what the argument of mine is, that they're bigger than mine, or that is it just a precedent thing? Is that valid enough? I'm not sure, because that's one of the reasons why I wanted to get it in the beginning, because I saw other neighbors had it. And I thought that, and I had actually been in that home, and I liked the idea, and that's why I decided to stay. But I just wanted to add that last thing, that was one of the reasons that I wanted to actually do this project.
Madam Chair.
Go ahead, Mr.
Do you mind if I address that?
Certainly.
Yeah, it cuts both ways. I think it's not clear that the BZA, like a court, is bound by precedent. It seems like we're not as much bound to precedent as a regular court would be. But in a certain way, it almost cuts against you, because the law says that if we get 1 and 2 and 3 people who come in for a particular kind of variance, and then other people see that, and then we get 1,000 people who come in for the same kind of variance, that means we screwed up, because we're not supposed to do these by the dozens, by the hundreds, by the thousands, right? And so the more people who are similar, who are coming in for the same thing, the less and less it's appropriate for the BZA to do it versus the county board. So it cuts both ways.
Okay, thank you.
I was going to call the roll, but I just want to make a comment that, we're going to make we're going to call the roll, and if we have a deferral, you'll come back in October, but there's no guarantee of which way this board will vote in October. And the question really is, from your side, can you live with a smaller structure? Are you prepared to move in that direction? So, because we don't want to hang you up for months, because I know this is pressing for you, but that could be an option that you're looking at, not to prejudge any outcome in October. Mr. Hamady, you have your hand up too.
Yes. Well, I have a comment about this house as a contractor. I mean, they're going to have their in-laws in there. And when I look at that place, I'm thinking about all kinds of stuff. Like, they're coming in. If that house, let's God forbid, catching fire, then they're upstairs, there's not enough room to escape. It's like they need to open more space to be somewhere. Like, it's just it's just too small. And in any way you can look at it, that may cause problem for them, and especially the 4 people there.
I hope you're not saying that the current structure is a fire trap, because.
No, I mean, I'm just saying it's just like when you go upstairs, there's not room to escape. I mean, I'm coming up with excuse to get this.
Well, you will be responsible for figuring out the design, one way or the other. But we're gonna call the roll now on the motion to defer to October 14th.
Sure.
Mr. Owen.
Aye.
Ms. Freshman.
Aye.
Mr. Melnick.
Aye.
Ms. Clark.
Aye.
Chair votes aye. The motion to defer this item to October 14th has passed. So I hope you can join us in October. Thank you. Mr. Rissy, will you call the next item, please?
Yes, the next item is case number V-11564-20-UP-1. It is a use permit request by James and Nicole Clayton. The owners permit a street setback of 16 feet to the wall, 15.5 feet to the eave, instead of 25 feet to the wall, 21 feet to the eave as required in the Edison Street right-of-way regarding a new detached accessory building garage on a corner lot on the premise known as 5100 23rd Road North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Okay, thank you, Mr. Rissy. Any questions for staff? Is Mr. Melnick still with us?
Yes, I'm with you.
Okay. Thank you. Any questions for Mr. Rissy? All right. Is the applicant Mr. Kachling?
Yes, it's Mr. Keeshlin and Mrs.
Keeshlin.
We are here.
Thank you.
Hello.
Hello. Do you have video that you can turn on?
I think we just did. Can you see us?
Yes.
You're coming in now. Okay, there you are. Welcome.
We did our best. We just worked out.
Make every moment count.
That's right.
Do you have anything you'd like to say on behalf of your application?
Sure. Yeah. So I think I just, first of all, thanks for the consideration. As you can see in the picture that's brought up on the screen here, the subject property is a corner lot. There is an existing retaining wall that actually cuts across the lot from the rear property line to the lot sideline. And in the picture there, you can see there's a pretty mature tree. We've had an arborist out before. It's an 80-foot, 85-year-old tulip poplar. And so, considering that, the trees there, the proposed placement of a garage is already within the existing footprint of the existing driveway, which you see there. And this limits the amount of obviously newly disturbed and developed area. The proposed placement would obviously also allow for more separation from that large tree that sits off the right or the west side of the property. And so for these reasons, right, I think, the project may be seen as helping to preserve some of the historical trees, foliage, et cetera. And so that's, part of the request and why we've made the request there.
Thank you. Any questions for the applicant? Does the fence belong to you?
It does. Yep. So the backyard, the back line fence there, you can kind of see the coloring on it. Yep.
Mm-hmm.
Is our fence, and the fence that's actually sharing with the neighbor there is actually the neighbor's fence.
So the fence that's left of your driveway is your fence?
Correct. Yep.
Because I've noticed that it's kind of slightly off your property line.
We actually got permitting for it, and it was.
No, it's not. It's not. That's not a problem. I'm just noting that.
Okay.
You actually had a little more room there.
Okay. Gotcha. Yeah. I think there was some extra. So there is a there are some businesses. So Preston's Pharmacy and a couple of businesses are the alleyway there, and there are a number of trees that are actually behind that I think have been planted by the businesses. And so in order to actually move the fence even, further towards our lot line, it would have required a bunch of trees to be removed again. So we're tree people. We like the cool trees around Arlington. And so we try to preserve those things. And so, we made the decision to keep it on a little bit more inside of our property.
Okay, good. Any other questions for the applicant?
Madam Chair.
Mr. Owen?
This photograph is the best view to show what you're doing. Like standing in this spot seems like the best place to see it all.
Yep.
Right behind the cameraman or woman is one of your across the street neighbors.
Correct.
Do you have written feedback from them about their opinion about what you're going to build right in front of their door?
Yeah, so we did receive a letter of support from 5105 23rd Road North. Now that's directly in front of our house.
Yeah.
The home that you're speaking to where the picture was taken from is 2301. And then there's also 2305 North Edison. And those are basically the two properties that you see. We did have conversations with those people. They had no objections, but they felt, I will say they are a bit older. They've been in the home since the late 80s. And so, they weren't willing to necessarily type up an email and send it through. But we did have conversations with them, and those conversations were had, within the last month or so. We also had conversations with our direct neighbor to the left of us. and then as well as the people directly in front of us. So while there's no letter for those people per se, we did, communicate to them what was going on.
Do you happen to know the names of the neighbors at 2301 and 2305?
So 2301, I think is Nancy something. I forget her last name.
Yeah, I don't know her last name.
I forget the last names. Yeah, 2301, I believe. I don't know the last name. I believe the first name is Nancy. The 2305, I forget their names. Actually, 2305 is a good one because they've actually got I don't know if you can see in the picture, they've actually got a large detached garage in their backyard. So they were big proponents and big fans. We don't have a letter from them, but
okay,
they had already had that.
Okay. Did you by any chance contact the property owners where the pharmacy is and talk to them?
So we did reach out to it's 5053, which was Dominion Electric Supply, and 5101, which is Preston's. So the one basically diagonal from our property line, and then the one right behind us. Yeah. And we went into the building, had the conversation with folks. I think, they weren't willing to, write something on the behalf, and I think it's partly due to those people weren't the owners.
There. Yeah.
They said, yeah, we normally don't get these types of questions, so we're fine with it, right? They said they'd let the owners know, but there was no, there's no letters from those folks as well. We did contact them. We did walk into the building. That's an easy one. You don't have to knock on the door. You can just go in. So
yeah,
we did do that one.
All right. I don't have any more questions on neighbor contact. So if my colleagues want to follow up, I'll pause.
Cool. Thank you.
I have one more question, but it's on a different subject.
Go ahead, Mr. Owen.
Thank you. So I had a little trouble from the drawings comparing the bulk of the proposed garage with the bulk of the rest of the house.
Sure.
And a lot of times when we get elevations, we get an elevation that shows all the structures on the property.
Right.
But the elevations we got for this garage are limited just to the garage.
Correct.
And so a rectangle on a piece of paper looks about the same size as a rectangle on the rest of the pieces of paper, right?
Right, right.
I was wondering, and maybe Mr. Rissy passed this question on to you in advance earlier this week, if your architect happens to have been able to provide us with a picture that shows the garage height and bulk in comparison to the height and bulk of your existing house.
So we did receive the comments and we did make the ask. I don't have the form per se in front of me. I did go out and actually we had some you can see the rear addition there, some work done in 2001 before we owned the house. And so I went back to old permits to figure out what the height of the home was, what the height of the garage was, and then actually what the height of that back fence was that was questioned earlier. And so that might help knowing those dimensions. I know it doesn't help with a picture or a drawing, which those folks are, they said they run for us.
I'll take whatever you can give me.
The overall home height right at the peak is 24 feet. The overall garage height is 15 feet, 7 inches and 3/8 inches. And the fenced overall height is 7 feet exactly. So you can imagine it's kind of a slope, from the 24 down to the 15, 7, 3/8 down to the 7-foot fence.
Thank you.
Yep.
Yeah, we do have the garage dimensions in the packet. Any other questions for the applicant? How about just one brief question for Mr. Rissy? Mr. Rissy, in your staff report, you mentioned the mature tree. As being a feature that justifies the application. Do you equate mature tree and significant tree similar?
I don't.
Okay.
The mature tree is part of what the applicants put in their application, so I conferred that information to the board as I thought it was relevant to help make their argument apparent for the board.
Okay. So it's not necessarily a significant tree.
Well,
Thank you.
that's up to, Madam Chair, that's up to us.
Yeah.
Okay. Is it to define significance?
Well, we wrote a letter to the county board and asked them for guidance, and they've refused to give it so far. So I guess we
So
still
far.
have to wing it for now.
Okay. All right. Any other questions on this item?
No, Madam Chair, I'm prepared to make a motion.
Go ahead.
Okay, so in case V115642-UP1, I'd move that the Arlington County Board of Zoning Appeals adopt the proposed resolution granting the use permit request with the conditions as stated, including the 3-year period after which it would expire.
Second.
If there isn't a building permit issued.
Thank you.
Second.
Is that Mr. Owen?
Yes, ma'am.
All right. Motion made and seconded by Mr. Melnick, seconded by Mr. Owen to grant the use permit. Any further discussion?
Madam Chair.
Mr. Owen.
This is an unusual site. It's part of a very well-defined development. All the other houses in the development could not accommodate an outbuilding like this. It would not be compatible on almost all the other sites in the neighborhood. But this particular parcel is at the edge, and not just at the edge of the development, but also, backs up on highly commercial property. And so as a boundary condition, and this is alluded to in the staff report, it's difficult to analyze using our most traditional methods, because if we just looked at, is it compatible with the homes to the northwest of it, the answer would be no. But, if we look at it in the context of the commercial buildings to the southeast of it, it's a much more nuanced question. But I really want to focus on what you were just talking about, Madam Chair, about the tree. I suspect that when the county board wrote the part of this ordinance that mentions significant trees and foliage as a factor for granting use permits, this is probably exactly what they meant. That if you didn't think about trees at all, we might say, hey, you have plenty of room to scoot your garage back where it's not as prominent, where it's not as visible. Just move it to the back of your property or to the to that fence line, and then it would be more compatible with the rest of the neighborhood. And it seems like the county ordinance specifically says, but if there's a really super tree there, a significant tree there, then that's a reason to grant the exception. So to me, that's probably the most likely thing that the county board meant when they talked about significant trees and foliage, was a situation exactly like this. So that's why I seconded the motion. I think even though our traditional analysis doesn't seem on paper to support this quite as well as you might like, the actual unusual conditions on this site, I think, do support it.
Any further comments? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to grant the use permit carries 5-0. Your use permit is approved.
Thank you guys.
Thank you all.
And Madam Chair, I also want to say that it was very helpful that the applicants did that extra outreach to neighbors and that additional research. That was very important to being able to decide this tonight. So thank you for doing that.
Absolutely. I'm glad it helped. Thank you all.
Mr. Rissy, will you call the next item?
Yes, the next item is case number V-11565-20-UP-1. It is a use permit request by Jeffrey Keene, the owner, to permit a left side setback of 4 feet to the window well from the property line instead of 5 feet to the window well as required, regarding new egress window well in the R6 zoning district on the premise known as 5644 19th Street North, staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. And I'd like to please note that there's supplemental material for this case that came in after the application packet was assembled and printed. We have a couple of additional letters from the neighbors.
Okay, I see 2 letters. Any questions for Mr. Rissy? All right. I think the applicant has joined us. Are you Mr. Keene?
I am.
All right. Is there anything you'd like to say on behalf of your application?
Honestly, I spoke to the neighbors right immediately next to me who just did a huge renovation of their home. They have no issues whatsoever. They actually have a son, my son's age, so he'll probably be over at our house once we renovate the basement. So this is part of a larger like basement waterproofing, and this is why we're doing it now, because we'll have that side of the house dug up, and so we get a discount on actually installing the egress window well where there is already a window well. And that side of the house will have the kind of family room renovation down below it. So it would be nice to have an egress window well down there as an extra escape route, because there's no way of getting out any other windows because the house sits so low. So there's only one way to get out of the basement right now, which is actually right next to the kitchen. So if there was a fire, which probably would be in the kitchen, the one stairway out of the basement would probably be blocked. So I think it's extremely important that we have a separate way of getting out of the building. And our future renovation plans are to have a kind of front porch area and a back sunroom area, which would block the back part in the front of the house. And the other side of the house, the far side, has all our utilities on that side, including a bathroom, washer and dryer, and then electrical boxes and all that other stuff. So this really is the kind of the best place for it, and it makes sense right now as we're doing the basement waterproofing to do it now.
Okay. Thank you very much. Any questions for the applicant at this time? All right. I don't see any speakers, right? All right. Discussions with the board.
Madam Chair.
Mr. Owen.
Thanks to the completed neighbor outreach, this is an easy case in my view. I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11566-20-UP-1 subject to the conditions listed.
Your second? Seconded by Ms. Clark. Is there any further discussion?
Madam Chair?
Oh, Madam Chair, I missed
I'm sorry.
I ask unanimous consent to reframe the motion as relating to V-11565-20-UP-1.
And Mr. Owen, did you add the condition?
Oh, yes. And I ask unanimous consent to add 3-year building permit limitation.
All right.
I should have left this to you, Mr. Melnick. I'm sorry.
Clean up. Is that what you want to add, Mr. Melnick?
Yes, that's right.
All right. So we have a motion that includes an additional condition for an expiration date. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. Your use permit is granted, Mr. Keene.
Thank you.
Mr. Rissy, will you call the next item?
Next item is case number V-11566-20-UP-1. It is a use permit request by Davis and Sheila Leonard, the owners, to permit a right side setback of 4 feet to the porch, no eave, instead of 10 feet as required from the side lot line, and to permit a left side setback of 8 feet instead of 10 feet as required from the side property line, and to permit an aggregate side setback of 12 feet instead of 18 feet as required regarding a front porch expansion in the R6 zoning district on the premise known as 5707 5th Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? Mr. Rissy, I was trying to understand what's happening in this application. I guess just reading the staff report, it appears that there is currently at least a partial porch existing.
I would say this much of the porch is existing. So they built a porch that conforms to the setback requirements, and they're looking to expand it so that it runs the full width of the house.
All right. All right. So do we have an applicant, Carlton Davis or Sheila Leonard?
Yes, ma'am. We're both here.
Do you have your video on?
It should be on.
All right, it's coming on. There you go.
Okay.
Takes a moment to come on at our end. Is there anything you'd like to add to your application?
No, I'm glad that we're going at this point in the evening after back to school night, so we can both be here, which is great. But no, we purchased the house about a year ago. We actually bought it from the grandson of the original owner of the house, dating back to 1940. So it had been in the house for 80 years, 79 years. They wanted to sell it to a family who would move into the neighborhood and be established in the neighborhood for some time. There are 2 lots directly across the street, which had been split, I think, last year by a developer, and 2 new houses were built. They were not interested in doing that, even though they probably could have gotten more money. So we wanted to maintain sort of the charm. The picture that was there has the original brick from 80 years old, and just sort of add on to the back of that. And we would, we'd love our front porch. It's on a cul-de-sac. Watch the kids bike up and down. Just sitting in a very pretty tree in the front yard, just enjoy the tree. And it would be nice, symmetrically, aesthetically pleasing to the eyes with a symmetrical front porch going length to length of the original structure. And it's sort of a seamless blend of old and new. We're very excited about our house.
All right. Okay. Any questions for the applicants?
Madam Chair. I'm a little bit confused about the stairs in front of the house.
I'm sorry, about what in front of the house?
The stairs?
Yes, okay.
From the porch to the ground?
Yes.
In front of the house?
Okay.
So it seems like the porch is actually quite high up off the ground in that location. That's what I seem to remember from visiting the site. How do you know how high off the ground the porch is?
Yeah. So first, I'd say that I believe this was already approved for our construction permit, the elevations, but I believe it's 61 inches above the ground. 61 inches.
Okay, so maybe about 5 feet off the ground. What is the? Oh, I see. You're saying that the middle of the porch is already by right built and approved.
That's correct. It's the
so your use
right
of
the house
is just for 2 ends of the porch, and you're not meeting the use permit to apply to the whole porch because you've already built the center of the porch by right. That's your statement.
Yes, sir.
Okay. So my question is then to Mr. Rissy, I guess, are the front of the stairs of the already approved porch more than 25 feet back from the street right of way?
The stairs of the porch don't need to be 25 feet back from the right of way.
What's stairs how far back from the right of way do the stairs need to be?
5 feet.
Oh, just 5 feet. So
yeah,
just the porch
to 5 feet from any property line.
So the front of the porch has to be 25 feet back. but the stairs can go all the way up to 5 feet away?
The front of the porch can be 21 feet back, but the stairs can be up to 5 feet away, correct?
Okay. Sorry, I had misremembered with the requirement. Okay, so so the center of their porch is already built, approved, by rights, no issues. Okay. All right, well then, I don't have any more questions about the dimensions. I do have some questions about discussions with the neighbors. I did not see written feedback from the neighbors on the right-hand side of the property. Can you talk about any outreach that you may have done with those neighbors?
Sure, I'd be happy to. So we bought the house a year ago. We've never lived in the house and subsequently never lived in the neighborhood. Back in July, I took 2 of the kids actually, and we went door to door and knocked on everybody's house, introduced ourselves to most of the people who we had not met before. So the 2 people directly to the left and right, the people across the street, the people diagonally across the street, and the people behind us. Everybody, I was able to talk to everybody except for one person diagonally behind us who did not answer the door. And what I did was I wrote a letter basically introducing ourselves, basically thanking them for dealing with our construction project, which a lot of the parents actually appreciated because it gave them something to do, walk up and down the street with their kids during the coronavirus. But it's generally not my nature to basically ask for favors, certainly not when I'm meeting people for the first time. So I wrote them a letter basically saying what we were doing. I also sent them, and I think you have 2 that have been returned, give them a little sheet for them to sign, put a self-addressed stamped envelope back so they could put it in the mail. They could drop it off in our mailbox, whatever they felt comfortable doing. We had one person respond. I mean, nobody objected to what we were doing. Nobody objected. It was actually a good way to meet the neighbors and introduce ourselves. Only one person returned it in our envelope, the envelope in our mailbox. And then actually a couple of weeks ago, I was over looking at the house, and a neighbor across the street saw me and ran over to me and said, I've been looking for you. I wanted to give you this. And I hadn't seen him in 7 weeks, and he gave me another submission. I don't know why he handed it to me when I gave him a self-addressed stamped envelope, but he did. It was a good chance to see him again. But we talked with everybody, with the exception of down on Kensington. There's a long, narrow lot. Not that one, but sort of it.
56.
It's not the blue one. It's in front of the blue one. Right where the arrow is. Anyway, those are the only people I didn't talk to. Talked to everybody else, and everybody else, did object and express support.
512 Kensington is the one you couldn't reach.
Yeah, it was. There looks like there's a white truck right in front of it. That's the house. That's the house.
I can see it on our map.
Yeah, I left something in their yard or in their mailbox. I think they had a big no solicitation sign on their house. But those are the only people I did not talk to in person or hear from in any way.
Okay. Your most effective neighbor is the neighbor to the right side of your property.
Correct.
703. And you say you did talk with them?
Yeah, first time we talked to him, we mentioned it. He said he probably wouldn't have a problem with it. And then we talked to him again. He said he wouldn't object.
Do you have his name?
Tim and Jessica. I don't know their last names, but it's Tim and Jessica.
Okay.
They have 2 boys.
All right. Thank you.
I'm on the line.
I will also just add that we didn't really press anybody because we already are having a construction done on the house while everyone's locked in their homes. And so we're trying to, it's already such an inconvenience to people. So we certainly didn't want to ask people for more.
I looked at some other applications on the docket tonight from earlier, and they basically had we don't object or something. And then they had everybody sign sort of, in sequence. Maybe that would have been a more efficient way to do it. That never crossed my mind to do. It seems slightly less personal, if not more effective. Again, this was the first time for us meeting most of these people, and that's just something that, didn't want to push, as Sheila mentioned.
Okay. Thank you. Any other questions for the applicants? Okay, the discussions with the board.
Motion?
Ms. Freshman,
I'm prepared to make a motion.
please.
Dude, really?
I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11566-20-UP1, subject to the conditions with the addition of the 3-year time limit.
Is there a second?
Look at the plan.
Who's speaking? Do I have a second? Ms. Freshman has made. Mr. Melnick seconds the motion. Thank you.
Okay.
Madam Chair,
Mr. Owen?
I think this is a tough case for me. I find very compelling the applicant's argument that they are not doing a tear down in the shotgun style house that is common in this part of Bluemont, that I think is not compatible with the character of the neighborhood. That's commendable, and it doesn't seem like such a big deal to expand the front porch. We like front porches, but I'm just super nervous that, even we were a little confused about the exact dimensions and placement of the final porch that they're asking for. And I'm really nervous that it might be a surprise somehow to the neighbors at 5703, who might lose part of their, sense of view or privacy or something that we didn't realize was important to them. And so I'm just saying I'm really struggling on this one because it does kind of seem extremely reasonable, but it's just very, it just would have made things so much easier if we had a written approval from 5703.
Mr. Risley, were letters sent out to all the neighbors?
Yes, Madam Chair.
So 57-0, I share your concern. I would love to have had positive feedback from the most affected neighbor, but
I'm on the phone right now.
Who is speaking? Who do we need to mute?
5703.
It sounds like the most affected neighbor.
Are you joining us?
I want to make sure I'm monitoring the way the board reviews the application.
Did you want to speak?
No, I just want to make sure the facts are entered accurately. I think I'm going to speculate here, but I think the reason letters weren't returned by neighbors was because many neighbors didn't approve of the request for variance.
Madam Chair, can we get the name and address of the person who's speaking?
Could you identify yourself, sir?
Yeah, I'm at 5703 5th Street North. This is Timothy Cripps.
Well, you are the most affected neighbor. Are you supporting this application?
I just haven't seen the full plans for the porch, and it's unclear to me how obviously it impacts our property. And I told Carlton and Sheila that we're not going to contest it. I'm not here to contest it. I just want to understand the ration for how this is being evaluated. I've sat through all the other kind of applicants tonight. So I think my wife and I would be fine sort of going along with this if we could just see the final plans for the porch and how it's going to be constructed and how it would impact our property. In other words, how is the base of the construction going to be created? Is it stone? Is it wood? Because it is quite close to our property, and we just, we haven't received that information. And I think it would be useful for us to make the final ruling on it, from at least in terms of blessing it.
Well,
I think it would be useful too. So, Madam Chair.
Yes.
So, as we all know on the board, it's very common for us when we have some neighbor concerns like this for us to defer for a little while on the application and allow the neighbors and the applicants some time to exchange information and have a constructive conversation and see if questions get answered that way and there's more comfort, later on. So, so that would be my inclination on this.
Well, we have a motion on the floor that we haven't acted on. So do you have a substitute motion you want to create?
Well, Madam Chair, Ms. Freshman has raised her hand. Maybe she's going to make a unanimous consent request.
Ms. Freshman.
What I'm going to do is ask the applicant to respond to the gentleman who called in. Because I don't know that we have a photograph of the existing porch. They can describe what they intend to do in terms of surfaces. I'm not sure whether or not that is sufficient for the caller or whether they feel like they need to have a sit down and much more extensive drawings or something. But can we at least have that dialogue before we address postponement?
This is the 5703. I think if Carlton and Sheila can describe the plans for this. I mean, it sounds like the board has no major objections given the second of the motion. Obviously we're impacted, and I told them in my written correspondence to them that I wouldn't contest this, and I'm not contesting it. I just want to make sure that we have a say in what is going to be 3 feet from our property, or at least kind of understand what that is. And so if they could provide further clarity on the construction materials and what the plan is, I think we'd have a better sense of comfort. Obviously, it's a difficult time to start a relationship with new neighbors when this is sort of impeding on a setback. So I think we just want to understand what we'll be looking at when we open up our car door and their porch is right there.
Mr. Cripps, it is quite common for neighbors who are even good friends to want to have information about their property. So there's no animosity should be suggested in this request. It is very common to want the details. Mr. Davis, Ms. Leonard, you do not have drawings in your packet of what the new porch will look like. Is that correct?
Yeah.
Or is it going to look like what's in there except extended?
Yeah, I mean, obviously it's gonna, it's not gonna look like that. It's gonna be finished. But you can look at the left side. It'll just be extended off to the right side. So it's flush with the end of the house. And then the porch itself is just going to be composite Trex that most people have. And underneath is going to be it's going to be wood. It's not going to be stone. It's going to be wood.
But you have drawings in this package in the application. And so what I'm asking is the package, are these drawings representing what the porch will look like except extended?
Right.
I'm sorry, hold on one second.
Sure, take your time.
Oh, yes, that's correct. Yes, ma'am, that's correct. I'm looking at page
like A202.
8202. Yeah, that's right. A202. That's correct. So the upper left drawing, it just extended off to the right, and then the left side of the upper right drawing is going to be what it looks like from Kim's house.
And white, of course, not.
Yeah, it'll be white. It'll be painted white. Yeah.
What will be painted white?
The railing and the railing, and then the support structures that's holding up the roof.
Okay, Mr. Cripps, do you have access to the application?
Yeah, I saw the drawing. It's hard for me to tell from the elevation what the base would look like. Whether it be would it be lattice, or whether it be kind of posts, or whether it be covered. I think that was the question we had.
Okay.
Yeah, Tim, I think Tim, I think it's going to be, it's either going to be, it's going to be wood. It's going to be, I think it's going to be planks of wood is what it's going to look like. It's going to be, it's going to be done in a professional, good looking manner. Do I have a photo of it? No, I do not. But if you look at the porches across the street, those are stone with cement. Ours will not be that. It'll be different than the ones across the street, the new builds from last year. It's not.
And I'm not sure what you meant by covered, but it'll be obviously like enclosed.
It's not going to be open like the picture is right now. I mean, obviously it's a construction site, but I mean, you're not going to be looking at a giant hole. That makes sense.
So it'll be
That's
white
definitely
wood
not the case.
all around.
So, from your point of view, you get out of the car and you look at it. From our point of view, I mean, we're walking in the house and looking at it, so we're going to want it to look good too, obviously.
So I'm not, I don't live here and I'm having trouble understanding exactly what you're saying. The drawing here shows a dark facade against which there is a white railing porch railing, right? And that's correct.
That's correct.
And then that's just going to extend to the right side of your house.
That's correct.
As will the roof. So it'll just be symmetrical.
Correct.
And then below the railing will be wood siding.
Correct. It's not. I'm sorry. Go ahead.
It's not siding. It's wood.
Yeah, it's not going to be. The picture indicates there's nothing underneath. There will be some type of wood structure underneath. Wood.
Those two planks I see there are not representative.
Madam Chair.
Yes.
This relates to the question I had before. The drawing seems to presuppose that the deck is far less than 5 feet above ground level.
Right.
But in fact, there's going to be 5 feet of substructure. It's going to be made of something, and it's going to be prominent visually to the neighbor. And it's treated on these drawings as if it doesn't exist at all. And so that's similar to the question that I had. I feel like this is information that the architect might be able to more fully develop, not just to inform the BZA, but also the neighbor.
Yeah, typically we whatever is in your package is what we expect would be built. And this is not obviously what you expect to be built, right? You expect the porch to look different than this. I would not be opposed to a deferral to get a drawing of what this porch is going to look like when it's completed, both for us and for the neighbor.
Madam Chair. Yeah, I totally agree. It just looks like these drawings don't really look anything like that. So I'd be in favor of that.
I do know, in a gesture of good spirits to our neighbors, because we're anxious to have them in, and obviously for their construction to continue. And I think they're at a bit of a stopping point. I don't know how this works from like a county reviews standpoint, but I think obviously we'd like to be kept abreast of what the plans are to finish off that facade. That way we just know what the impact is to us. And I think that's really the only thing that's sort of like a cause for concern at this point. So I don't know whether there's a motion that the board could file where construction contingent on us kind of working this out as a sidebar conversation even.
Madam Chair.
Mr.
So the usually we defer for 2 months or 2 meetings, I guess, depending on how you define it, for these kinds of conversations to occur. given the scale and status of the project, I would certainly support deferring, as we did with the other one, to the middle of October. What's it, October 15th, 13th, something like that?
14th, I think.
14th. So exactly a month. And then so construction of the addition to the porch would have to wait until at least then to occur. But it's as you said, Madam Chair, it's very normal and typical and usual for us to get this information. And I think we need it for ourselves. So I would support just the normal deferral that we did on a previous project tonight to the October meeting. And that should be plenty of time for the applicant to get drawings, to share them with the neighbor, to share them with the staff, to quickly re-advertise. And next thing you know, it'll be all ship-shape, I imagine.
I would support that.
So, Madam Chair, I ask unanimous consent to ignore or to take no action on the motion now pending to approve and allow a new motion to be offered.
Any objection? Hearing none.
Madam Chair, I move that this application be deferred to the October BZA meeting for the purpose of developing more thorough and accurate drawings and for to hear any additional feedback from the adjacent neighbors at 5703 and 5711 5th Street North.
We have a second for the deferral. I will second for the deferral. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
What was that?
Aye.
Ms. Melnick? Mr.
Aye.
Melnick? Ms. Clark?
Aye.
Chair votes aye. So we will have a 1-month deferral to give the applicant an opportunity to get a drawing of what the completed porch would look like so that they can share it with us as well as their neighbor, so that everybody is on the same page as to what is going to be built. Thank you very much. We'll see you in October.
Thank you.
Mr. Rissy, will you call the next item?
Madam Chair, before Mr. Rissy calls the item, I'd like to offer a motion.
A motion?
Yes, Madam Chair, I ask unanimous consent that we consider the next 2 items in one hearing, since they're so closely related. So I'd ask unanimous consent that Mr. Rissy call both items so we can consider them jointly.
Any objections? All right, Mr. Rissy, could you call both items, and therefore anybody that wants to speak on either item will be allowed to speak?
Case number V-11568-19-UP-1 is a use permit request by 3865 North River Street LLC, the owner, to permit a setback of 21.2 feet to the wall, 19.5 feet to the eave from the front property line instead of 25 feet to the wall, 21 feet to the eave as required. A setback of 17.4 feet to the porch, 15.8 feet to the porch eave from the front property line instead of 21 feet to the porch, 19.5 feet to the porch eave as required. 18.3 feet to the stormwater planter from the front property line instead of 21 feet as required. 13 feet to the wall, 10.9 feet to the eave from the left side property line instead of 16 feet to the wall, 12 feet to the eave as required. 10.2 feet to the stormwater planters from the left side property line, 12 feet as required. 9.1 feet to the areaway from the left side property line instead of 12 feet as required, and an aggregate side yard of 21 feet instead of 24 feet as required. Regarding a new single-family dwelling on the subdivision on North River Street in the R10 zoning district, premise known as 4156 39th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions, and I'd like you to please note there's supplemental material for this case that came in after the application packet was assembled and printed. We also have additional speakers. Case number V-11569-19-UP-1 is a use permit request by 3865 North River Street LLC. The owner's permitted setback is 16.1 feet to the wall, 13.1 feet to the eave from the front property line, instead of 25 feet to the wall, 21 feet to the eave as required. The setback is 18.1 feet to the porch, 16.5 feet to the porch eave from the front property line, instead of 21 feet to the porch, 19.5 feet to the porch eave as required. 13.5 feet to the stormwater planter from the front property line, instead of 21 feet as required, regarding a new single-family dwelling on a new subdivision on North River Street in the R10 zoning district, premise known as 4155 39th Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. I'd like you to please note there is supplemental material for this case that came in after the application packet was assembled and printed, and we have additional speakers for this item as well.
Thank you, Mr. Rissy. Any questions for staff?
Madam Chair,
Mr. Owen?
I would ask staff to briefly describe the additional materials and state whether or not they've been provided to the applicant.
The additional materials are additional letters from the neighbors, and yes, the applicants received an email this afternoon notifying them that supplemental material has been provided for their case.
Thank you very much, Madam Chair.
Any other questions for the applicant or for staff? All right, let's hear from the applicant.
Madam Chair, before we hear from the applicant, I'm wondering, are you intending to give them 10 minutes as you are combining the two items?
Sure.
That would be only fair, Madam Chair.
Granted.
Uh-huh. You get 9 plus.
Can you hear me okay?
So far.
Okay, great. You all have trained us well to go out to the neighbors. And this case is the result of the kind of interaction you all encourage with neighbors. And it's an example of what can happen when the neighbors and developers both work in good faith towards the mutual goal of addressing each other's concerns. This is pretty much a win-win. I'm going to quit speaking at this point because I think Mr. Rissy did a really good job in presenting the justification for the request. But my clients, who I hope can participate, would like to share a little bit of the history of this with you all, if that's okay. Emile or Lavu, are you all ready to speak?
Yes, and good evening, Madam Chair, dear board members, staff, and neighbors. My name is Liviu Floroie. My partner, Mr. Emil Simonov, who is also attending this meeting, is the other managing member of the LLC, and we are a very small local developer who is the owner of the River Residences subdivision, where 4 new lots were created in a cul-de-sac and a generous outlot to be used as an amenity for the neighborhood. I would like to give a quick overview of the steps taken by us in developing the project and the relationship with the neighbors, and explain how our efforts led us in front of you today. Before applying for the preliminary plat of this by right subdivision in February 2018, we contacted all 17 surrounding neighbors by knocking at each neighbor's door. We spoke to the ones that answered and left an introduction letter to all of them. We also attended a meeting with a local HOA. At the time, nobody expressed concerns about the development. Quite on the contrary, most people were supportive of it. With this in mind, we have hired Walter Phillips to do the civil engineering work, and Thomas French, a well-known Arlington architect, to design an American shingle home that we believe would fit well in the chain bridge for his neighborhood. We also hired Walter Phillips, landscape architect, and Skidder, to design the landscaping plans for the subdivision using local vegetation. These plans were approved by Arlington County in January 2019. After the CEP was approved and we started the site work around June 2019, it became more obvious where the 4 new dwellings will be located. A few of the neighbors who are now part of the agreement were particularly affected and expressed concerns about the privacy of their homes. In response to these concerns, we had hired another experienced and respected landscape architect tasked to help us develop a landscaping plan meant to resolve the privacy issues raised by the neighbors. In addition, we have worked with our engineering company, Walter Phillips, to try to move the houses and improve privacy for all parties involved. The neighbors wrote a petition that was later delivered to the county in September 2019 and also engaged legal counsel. This actually facilitated a more organized communication between us and the neighbors. And after several meetings with the neighbors and their legal counsel, we developed an agreement to address their concerns. We spent tens and tens of hours working with engineers and various architects on this. The agreement effectively mitigates the impact of the new development by addressing two key aspects. The first one is the location of the new plantings and fencing included in the landscape plan, which would provide screening beneficial to the neighbors and the future residents alike. The second one, for the concerns about the health of certain trees on neighboring properties and the proximity of new houses being detrimental to these trees and to the intimacy of the neighboring houses, we worked with our engineers to move further the houses from the property line and applied for this exception. As a side note, several months earlier, we had also reached a similar agreement with the neighbors of house number 2 of the subdivision, Mr. Ozi Akai and his spouse, for planting trees in the back of house number 2, and we moved the new house as far as we could within the permissible limit. In this instance, we were able to do this move without needing to apply for an exception. This entire process has not only been time-consuming, but also very expensive. However, we are very happy to have worked with the neighbors and create a more sustainable development and would make an integration of the new dwellings more natural and harmonious and give everyone the privacy they need. The fact that we had meetings in person and visited the homes of the following neighbors, Traveling McCurdy, Russell Palmer's, Klaas, Crawford, Akai, Menheinigen, Demote, and met on our property or in one of the above neighbors' houses or in the neighborhood with Mrs. Sagan, Mr. French, and the Yingling family, and had spoken on the phone with Mrs. Papadimitriou, should be a display of our strong will and good faith for addressing these concerns. And we are really proud to be here together with some of them as a result of our collaboration. Thank you for considering our case and hearing us tonight.
Thank you. Any questions for the applicant before we take the speakers? Mr. Rissi, do you have a speakers list? I'm going to ask, are there any other people in attendance who are not on the speakers list that will wish to speak tonight?
Yes, I would like to speak.
Could you state your name?
Phil French.
Phil French. All right. We'll add you after Mr. Feinberg. Is there anyone else that wishes to speak? All right. Ms. Freshman, did you have your hand up?
Yes, it's probably more a question for Barnes, but who may not be surprised to hear me say that generally speaking, with new construction on a lot that is of legal dimensions and size, I'm generally not sympathetic to exceptions. I feel as if you can probably, when you start with a clean slate, you can build something that doesn't require any setback or other relief. Is that something that you actually considered doing in this case? Apart from, and it's separate, I see that as separate and apart from any of the issues raised by the neighbors and privacy and that sort of thing, which I commend you for working on.
Are you looking for a response at this point or later?
Mr. Barnes, or Mr. Lawson, you may answer that question now. Go ahead.
Okay. How do I, let me try to share. The neighbor showed up at one of the county board hearings at public comment, and the by right subdivision had already been through the review process and was ready to be recorded, but for working out some issues with the county attorney. And the chairman of the county board approached myself and asked me to work with the neighbors and see if we couldn't resolve some of the concerns. The same message was extended to me by the county attorney. And so with that, we began our dialogues, and it became clear that if we could shift the houses on the lots, that we could accommodate some of the concerns that have been expressed. And by moving them the way we move them, there's no impact, no negative impact to anybody. And our moving them, we believe, comply with the ordinance and what it requires by way of being entitled to obtain a use permit. We shifted away from the neighbors in order to accommodate the topography of the neighbors and preserve significant trees, foliage, screening, and so forth. And so I would respectfully submit, and I understand your point, but I would respectfully submit that we meet the criteria of the use permit. And, you know, it does no harm to anybody, but it certainly does help our neighbors.
Thank you. That's helpful. I appreciate it.
Just a matter, I saw a hand raised by Emil Simonov.
Hello, hi everyone.
Are you, what were you asking?
Yes, I'm Liviu's partner and Barnes' client. We are the owners of the development. And just to add to Barnes' point, is that this was a by right development and subdivision. And we would have been okay with building the houses without moving them. But as we showed from the beginning of the process, going and knocking on everybody's door, all the neighbors, and talking to each one of them, we wanted to find a solution that would work for everybody. We have spent many of our hours and our consultants to be here tonight to make sure that our neighbors are happy and that the future residents are happy. We could have built them for the, codes from the beginning without needing this approval from the BZA. Yeah.
Thank you.
And thank you for hearing us.
Mr. Rissy, did you have your hand up?
I was only going to mention, Madam Chair, that I had 2 speaker lists for the 2 cases, so we have 3 speakers between the 2 items.
I'm sorry, could you repeat that? You have more speakers?
We had 3 speakers sign up for the 2 items. Mr. French rounds out the 3rd if we are just looking at this list.
Okay, so there's a total of 3 for both.
Correct.
Okay, thank you. All right. Shall we move to the speakers? Ms. McCurdy, are you with us?
Yes, can you see me?
Yes, I see you.
Yes, and this is my husband. I wanted to speak tonight in favor of this application. We feel that the by right, the original by right, if that's the way that it goes, will actually destroy at least one mature poplar because of the location of the retaining wall. And so they have, in part of their planning, they've moved out the retaining wall enough to put in a row of screening trees that will benefit both properties by providing, the second level of their new house would otherwise look straight into our bedroom windows and we into theirs. We don't really want to have that situation happen. And so we felt that this solution of moving the house a little bit further away from the lot, from our lot, would create enough space so that those screening trees can be put in. Without the board approving their application, then we'll be stuck with that situation. And the only way that we can get privacy back with our tree likely would die, and our only other means of getting privacy back is for us to plant bamboo instead. So we would do that.
Okay, thank you.
Mm-hmm.
Mr. Feinberg?
I have nothing more to add than what Carol McCurdy has already said. Thank you. I also would approve of this variance.
All right. Thank you, Mr. Feinberg. Mr. French?
Yes. I don't know if you can see me. I too, I have an issue where I don't know if you can see it on this photo, but beyond here, it's a topography. It slopes down to what, the developers are going to put up a 7-foot privacy fence, but with a very large house that's facing a southern direction. I'm not going to have much of an ability to grow any kind of foliage unless I move it back 18 feet and put it kind of on top of this hill or gully, whatever you want to call it. I would need to give up about 18 feet of my own property in order to get adequate screening from what is going to be quite a large house.
Mr. French, what is your address, please?
My address is 4016 40th Street North.
4016. Okay, you are right behind.
Right behind it.
Okay.
And the Bremers are to my left if you're looking at the picture.
Right.
So that's my concern is I don't know what would grow in such a gully with a very large house. The original plan was to be 8 feet from my property line. This moves it another, I think, 4 feet, 4.5 feet. So that's where I am. I don't know what would.
Your concern is that what vegetation?
Is privacy screening. And
okay, so the landscape plan that was agreed to, are you party to that agreement?
Yes.
All right, but you have a question about whether it's feasible?
No. My question is, without a movement of the house, I will not have enough sunlight to grow screening material close to the fence. I would have to move it back and give up roughly 18 feet of my own property in order to get enough sunlight to grow screening material.
Madam Chair?
Yes, Mr. Owen.
Just to clarify, Mr. French, are you saying that if we grant the use permit and they can move the house as proposed, would that solve the problem you're identifying? Or would
Yes.
it would solve the problem?
Yes.
So the reason you're supporting the use permit is to solve the problem you just described. Am I correctly
That's
understanding?
Right.
Okay.
That's right.
Thank you, Mr. Owen. That's very helpful. All right. Thank you, Mr. French. Any other questions for the applicant?
Madam Chair?
Mr. Owen?
What is proposed to be done with the outlot adjacent to 3977 River Street?
Yeah, so the outlot would be used as an amenity for the cul-de-sac, and it will belong to the HOA that will be incorporated, that has been incorporated for this development, and it will be an amenity for for children or for anybody that wants to use it. Underneath it is the stormwater management system.
Mr. Owen, it'll be conveyed to the HOA. I typically hold off on that just because I found it's easier for permits or whatever if it's the applicant still owning it rather than the HOA owning it. But it will be conveyed to the homeowner association.
And so, Mike, do I understand correctly that there's no above ground improvements proposed?
At this time, no, sir.
Okay.
It will be nice to.
Yes, sir.
We were wondering at one point, it would be nice to have something, some benches or something for people to enjoy this almost 10,000 square foot outlet that we dedicated for the community.
Yeah.
That is very rare to find in in Cambridge Forest. So
it does sound lovely. Is the landscape plan number 2? Does that encompass that lot? Is that part of the agreement that was signed with the neighbors, or is that outside of the scope of the agreement?
It's outside of the scope of the agreement, and it was the landscaping plan that was approved by Arlington County in January 2019. That was designed by Walter Phillips. That basically has sod and then boxwoods along the way and the sidewalk,
okay.
And some trees.
It's outside the parcel that's part of the application, so I don't want to go into too much detail, but I just wanted to clarify the relationship.
Yes.
So, all right, I have other questions, but I'll let my colleagues get a word in edgewise.
I'll let Ms. Freshman go, and then Mr. Lawson, you can respond to everything. Go ahead.
Just following up on that amenity, it sounds like a very pleasant spot. Is it going to be fenced, or is it going to be, in other words, is it space that the neighborhood might enjoy as well?
So I can answer this question. It's not going to be fenced. It will have boxwoods and very small landscaping around it to define it and to make it look nice when you come from the street. But no, yes. So it will belong to the HOA of this development. But I'm sure the neighbors here wouldn't mind if other neighbors will come and and enjoy it. Yeah.
Thank you.
Yep.
Well, you would think, but we've had applications where people fought over that kind of thing.
Oh, I see.
Mr. Lawson, did you want to add something at this time?
The only thing I wanted to share was to share with the Board of Zoning Appeals that all of this positioning of houses and all of the agreement was done by professional arborists. And the McCurdy's also had an arborist. And so this was done based upon their expertise and what they thought would be appropriate in order to preserve existing vegetation and to allow appropriate screening. I just wanted to share that with you.
Okay, Mr. Lawson, just to satisfy myself as to, sort of the extent of neighborhood outreach, is there someplace in the application, or do you have handy the addresses of the people that signed your agreement?
I think the applicant would be better to answer that question, and I'll defer to Amelia in the booth.
And just, if it takes you a moment to collect that information, I'd just like to see the location of the residents who signed the agreement to see if there's any gaps there.
Okay.
So I actually opened it on my other screen. So the signers of Oh, actually, let me see. I have it open. So we have, I think we have the Carolyn McCurdy and Russell Travers, Richard Klaus, and
What I need is their addresses, if you have, just to see where they are located around the site.
oh, okay.
I could quickly pull those up.
Yeah, if you pull them up while we're having other discussion, I don't want to hold it up while we do that, but I would like to just check that off. Ms. Freshman, did you want to speak? You're muted, but I think you said no.
Her hand was up by accident. Madam Chair?
Mr. Owen.
Who lives at 3977 River Street, and what is their view on all of this? They're the one neighbor that I didn't see anything from at any stage in the process.
I think, Emil, you can correct me if I'm wrong, as you enter the street is the property as you go down next, so you're passing the development and is the next one. So I think it's the Van Heinigen and Sunita.
And how did they participate in the discussion? And I mean, I noticed they were not one of the few that did not sign the petition to us in September, but they're also not part of this agreement, even though they abut parcel number 1 at a point of their property. So I was just curious, how did you talk with them, and what's their view? And maybe Mrs. McCurdy can assist us in understanding where they stand on all of this, or the applicant, anyone who's talked to them.
Yes, we have spoken to them. We actually visited with them, and I enumerated. They're among the people that we actually visited. We went to their place. We've made a significant improvement at the property by implementing the new stormwater management system. They had issues when there were big storms, as you know, the stormwater and the water collected from the road above would come down on our property and would end up into their pool. And I think, you know, they were really happy with the development, and that's probably the reason that, you know, they didn't sign in the first place, because this was an improvement to them, and that's what they mentioned when we met with them. We've been in contact with them, and we've corresponded with them, and they're looking forward for us to finish up the grading and to allow the storm water management system to function at full capacity.
Thank you. And Ms. McCurdy, do you have any information on these neighbors?
Yeah, I speak to them all the time. And yes, indeed, they are happy to have the stormwater system completed. They'll be happy to be secured and ensured that they won't have any floodwater on their property, but they're not directly adjacent to any of the houses. And so the distance and the setbacks were not a concern to them. And so while they objected to having all of the trees removed from the lot, they did appreciate the fact that the stormwater will be abated for them. Okay.
Thank you. That's very helpful. And while they're still checking, I have another question for Mr. Lawson. Mr. Lawson, there was a discussion about, or the other applicants can answer too, but there was a discussion that there's another side agreement with some other neighbors who I think may live on Ridgeview Road that was not part of our packet and didn't necessarily need to be part of our packet, but just for the sake of clarity, do you happen to know which address points were included in that additional neighbor agreement that we didn't get?
Mr. Owen, I do not, but Emil and LaVue can respond to that. I think they, on their own, went back and forth with Emil and LaVue. Emil and LaVue, can you share that?
Yes.
Absolutely.
So just so you know, Just by the way we get our information, we have this map, this one that's in our packet. And
Yes.
for us, the easiest way is to know the numbers of who was doing each round of communication. And that way we can just check them off on this map. So if you have available which numbers were part of which agreement, and then we can see who, if anyone, is left.
Mr. Siminoff, have you gotten the first set of addresses?
Yes, so for Mr. French, it's 4016 40th Street North.
Got it.
For Mr. and Mrs. Glass, 4025 38th Place North.
Wait, 4025 38th.
Yes, 40.
Oh, I see it. Oh, in the corner there. Okay.
4025 38th Place North.
I see. Okay.
Mr. Feinberg is 4004 40th Street North.
Okay.
And the side agreement, sorry, maybe I think I'm missing one address here, but the side agreement was at 3866 North Ridgeview Road.
3866, okay.
3866 North Ridgeview Road, Mr. and Mrs. Akai. And I think I'm missing one address, but
3860, is that in your?
Libby, do you have the development agreement opened up? So I have the French family, the class, the Feinberg. Oh, of course, yes, Carol McCordy. I'm sorry about this. Yes. And then 3853 North River Street. And that's the Travers McCordy family. Yeah.
So there's one house in particular that's adjacent to parcel 1. That's at 4024 40th Street. And that looks like the Russell house.
The Brummer last name, yeah. And maybe any of the names.
4024 is Brummer.
4024 40th Street is the name. I think it's John Russell Brummer.
Oh, that's Russell Brummer. Okay, Russell and Brummer are the same person. Got it. Okay, so Russell Brummer signed the agreement that's in our packet. Is that right?
Is that right, Libby? Sorry, we had. I think we had more neighbors in the beginning, and then I think at the end, I think only the people that were very interested in moving the houses stayed.
Yeah.
Yeah.
Okay. Yeah, I have a Brummer Revocable Trust trustee signed the main agreement, the one that was the central exhibit for our tonight. Oh no, but that's way back in 2014. What is this? This is weird. There's a page in the application, 2 pages before Exhibit B, that has a signature page from John Russell Brummer, dated October 6th, 2014. Oh, and here we go. The 14th day of March, I see. All right, so the 14th of March is the, anyway, it looks like Brummer agreed to this, the main agreement that was signed.
Yes.
That McCurdy also signed on March 24th. Is that right?
That sounds right.
As
Okay.
Mr. French has to stand up, maybe.
Yes, Mr. French?
No, that's all right. They you figured it out on your own.
Your
Russell-
next door
Russell
neighbor
was
is
part
Russell
of the
Plummer, who signed the
signature
same
group.
agreement you signed, right? Yes?
That's correct.
Okay. Sorry it took so long. And then the other question I had is, what about 4043 38th Place? Who's that and what's their status? So this is Ms. McCurdy's backyard neighbor.
4043.
38th Place. Looks like that might be Sagan.
Yes.
Second, yes.
Yes.
Yeah.
We had a meeting with them at the site, and I think they were very kind to actually the photo that you see. They redid their retaining wall and their whole fence, which was falling apart. And maybe the neighbors can speak to their position, but
Yeah, we gave them access on our property to do the works. Very good relationship overall, I would say.
Ms. McCurdy, do you have any observations about your neighbors, the Sagans, and their views on this situation?
Yes, they're supportive. They'd like to see the house moved. They understand our need for privacy. They are anxious to have the green trees grow up higher because what's behind that fence is a swimming pool, which they've just had rebuilt. It was falling apart, and they also discovered that their property lines actually, their original fence, which was put in with the house originally like, I don't know, 40, 50 years ago, actually encroached upon the property lines of all of their surrounding neighbors, and so they had to tear it out anyway and rebuild all of it, including the retaining wall next to it. So with the loss of all the trees there, they now will no longer have privacy from views from the houses. So they are anxious to also have the retaining wall moved away further from their new fence, where Liviu and Emile will be having their landscape architect put in some giant thuja green, the green arborvitaes, so that will grow quickly, hopefully, and screen views from both directions.
Thank you. That's very helpful. Madam Chair, I don't have any more questions about neighbor outreach. My next set of questions will be about landscape plan number 2.
All right. I left you guys for a moment. I dropped out, and I wondered, had we covered the letter from Russell and Barbara Palmer yet?
No, ma'am.
Okay, so we can add that to the list. Is there any other board members that have comments they want to make? Otherwise, I'll let Mr. Owen continue.
Madam Chair, I think it would be appropriate if you want to raise that letter, that now would be the good time to do it.
All right. So you all are aware of a letter that we received from the Palmers, Russell and Barbara?
We are.
All right. Can you tell me, do you know where they, I'm not sure. Oh, they're 3859. So they are expressing some concerns. They say they take no position on the applications, but they are concerned about the drainage system and its effectiveness.
I believe that's been solved by Walter Phillips, Emile Liviu. That's the solution that you described earlier as it heads towards River Street. Is that correct?
Yes.
To give you more context, when we bought the property, as behind lot number 3, at the corner of Mr. and Mrs. Glass and I think the Ingleys, there's a stormwater management pipe. And that pipe would basically dump all the water from the above neighborhood and houses, all the storm water, and there would be a stream that would go into this property, and then you would connect to another pipe somewhere down the property. Because the pipes were not connected, it really created in general, a hazard, and water would get around the pipe at the lower end, and sometimes you would get, you would get much more water than you would, you would want to in this area, and mosquitoes and all kinds of stuff. So by connecting the pipes, I think the stormwater management has hugely improved. We put our faith in Walter Phillips in Arlington County on the design that we executed. And right now, the stormwater management system, it's not yet functioning because there's still a lot of disturbed land, and we don't want all that mud to go into the stormwater management system. So on the road, we covered on the public road, there's portions of it covered so the water doesn't go directly into the storm system. And that will be quickly solved as we start building the houses and have all the stormwater management water, the stormwater going to the planter boxes and going to the storm system.
So when was the stormwater system finally designed?
It was designed and approved, I think, in February or March. So it was designed in 2018, approved around February, March of 2019, implemented, I would say from September of 2019 to maybe March of 20, or maybe early this year. I don't clearly remember when it was finalized.
Well, the letter from the Palmers is early September, so they're writing to us, I guess, with knowledge of what the stormwater system is.
Yes, so that's what I was saying, is that the stormwater management system right now, and I'll leave you complete my thought, is that it's right now has been blocked because you have sediment, and we have put this project on hold for the past 9 months to work the situation with the neighbors.
Is Travis available?
Yeah, this is Travis Brown with Walter L. Phillips, the civil engineer.
Yes.
So to Livia's point and to Emil's point, the stormwater management system has two main components. One is an underground detention tank in the outlot, which collects the water and detains it so that it has a controlled release. In addition to that, there's stormwater management planters on the individual homes. So those reduce runoff and treat water before it enters the tank. Right now, where the development is, they still have the majority of the space denuded, and so they can't allow water to enter the system directly at this point because it would be filled with sediment if they did so. And that's a normal practice during a construction project. Unfortunately, because it's taken so long to get to this point, it's been a prolonged process. And so that's probably what the neighbors identifying is that it's not functioning as, the design would be if it were completed. Obviously, the planter boxes aren't constructed yet. When those are constructed and everything is put online, it will detain water by a significant amount, which the neighbors should see make a dramatic impact on their stormwater, how they're affected by stormwater. And then furthermore, as Emil had alluded to, the segment of pipe that was missing on the subject property has been installed and a public easement's been dedicated so that all of the upstream water can now bypass within a hard pipe and isn't flowing overland into the properties downstream. So they've made a significant improvement already just by installing that system.
Okay. Mr. Brown, can I ask you, does this stormwater system require maintenance?
It does, and the applicant has filed a stormwater maintenance agreement with the county as part of their normal LDA permit process. And the